Today we finally settle the debate about Israel-Palestine protests on college campuses. Look, I'm a lawyer. I'm not an idiot. Now, these protests have been all over the news, whether it's Columbia in New York, UCLA in Los Angeles, or in the backyard of Dean Chemerinsky's home. For example, on the night of April 30th at the campus of UCLA, pro-Palestinian supporters had occupied an encampment they built near the campus for over a week, demanding that UCLA divest from companies tied to Israel's war effort and boycott Israel-run universities. That night, a group of masked people entered the encampment and violently attacked the pro-Palestinian protesters. This attack happened hours after the outgoing UCLA chancellor declared the camp illegal. The violence continued for hours while campus security stood by waiting for backup or further direction. Eventually, the California Highway Patrol and Los Angeles riot police were able to resolve the chaos, but by this time at least 16 protesters had been significantly injured. No arrests have been made as of the filming of this video. The UCLA administration issued requests for assistance from the larger UC system on April 25th and April 26th to deal with those protests, but those requests were subsequently canceled. So today we're going to talk about the legality of the protests and counter-protests at UCLA, Columbia, and the dean of the UC Berkeley School of Law, Erwin Chemerinsky's backyard. And what about the dramatic, sometimes violent responses to the protests? Now, immediately after the April 30th incident, UCLA and the California governor's office launched investigations to find who was responsible for the slow reaction that night. UCLA Chancellor Gene Block issued a letter to the UCLA community addressing the deep pain seen on campus and offering support to students, faculty, and alumni affected by these events. In this letter, Block also called for the encampment to be disbanded, saying, quote, "In the end, the encampment on Royce Quad was both unlawful and a breach of policy." He wrote, "It led to unsafe conditions on our campus and it damaged our ability to carry out our mission. It needed to come to an end." Now, if you've never been to the UCLA campus, the Royce Quad is about as central to UCLA as it comes. It's right in front of Royce Hall and the Powell Library, and there were many reports of students being accosted and prevented from getting to class because of this particular encampment. Though it certainly appears that not all students were prevented from getting to class. Now, pro-Palestinian protesters attempted to refortify their encampment and hoped to continue protesting on the UCLA campus, but on May 2nd, after a 9-hour standoff, which resulted in more than 200 protesters being arrested, the encampment was torn down by law enforcement for good. And tensions at UCLA had continued after the violence at the encampment. On Saturday, May 4th, around 20 professors protested outside of a gala held at the campus's Hammer Museum, where its outgoing director was being honored. Then on Monday, May 6th, several dozen more students were arrested. According to KTLA, these 43 individuals were detained for conspiracy to commit burglary and subsequently released after being processed. Now, protesters at other college campuses have been met with a much different reaction by college administrations. Columbia University student protesters built a similarly erected encampment on their campus, but no great incident of violence broke out there. Though instead, New York police broke into a campus building after learning that the building had been occupied, vandalized, and blockaded by protesters after the university asked them for support. Not surprisingly, Columbia has received mixed reactions to their response and their large-scale arrests of these students. But protesters haven't kept their activities just to college campuses. On April 12th, at a private dinner held at the UC Berkeley Law School dean's home, pro-Palestinian protesters interrupted the dinner to speak about tragedies suffered by Palestinians. Now, in the wake of all of these different events, many people have made a blanket pronouncement that all of these different protesters had First Amendment rights to conduct these protests. And similarly, others have made blanket pronouncements that none of these protests had First Amendment protection. But as usual, the truth lies somewhere in the middle because all three of these different scenarios are analyzed differently. Now, you're probably aware of the First Amendment, which protects the freedom of speech, the press, assembly, and the right to petition the government for a redress of grievances. But one of the most important considerations when discussing the First Amendment is to understand that the First Amendment only restricts the government. So the First Amendment can only be violated by government actors or entities. This means that when we're talking about whether someone's First Amendment rights are violated, we're necessarily talking about whether a government official or agency has prevented those individuals from exercising their constitutional rights. The actions of private entities or other individuals are most likely irrelevant to whether your First Amendment rights are violated. Asterisks, there are always exceptions to that. But traditionally identified as the four protections of the First Amendment, speech, press, assembly, and the right to petition the government for redress, protesting may involve all four of those rights. Now, to understand the freedom of speech, you have to understand what speech is considered worthy of protection. But generally, freedom of speech is considered the largest category. And speech has been interpreted by U.S. courts to include both spoken and written speech, as well as other forms of expressive displays. Essentially, all expressions can arguably be considered speech and protected under the First Amendment, except for the narrowly excluded categories explicitly established by the courts. These exceptions include speech related to obscenity, fighting words, incitement, and threats. And similarly, speech that explicitly forms the basis for a legal claim, such as defamation, fraud, and speech integral to criminal conduct, will also not be protected. Now, once we've established that the incident incident of speech does not fall within one of the narrowly defined exceptions to the First Amendment protection, we can move on to consider what level of scrutiny the government will apply to consider the speech's deserved protections. Scrutiny essentially just means the level of justification that the government has to have in order to restrict anyone's particular speech. And as we've talked about many times on this channel, often the whole ballgame is what level of scrutiny is applied. Now, there are generally two types of scrutiny that apply to speech-based regulations: strict scrutiny and intermediate scrutiny. And it all depends on whether the regulation is content-based or whether it's a content-neutral regulation. Now, content-neutral regulations are government actions which regulate speech incidentally in order to achieve some separate purpose apart from the content of the speech. And there are three basic categories of content-neutral regulations. The first is a time, place, and manner regulation, which is meant to restrict the time, place, and manner of how speech can be expressed. A typical example of a time, place, and manner regulation is a local ordinance permitting signs to be posted a certain number of feet away from roadways within city limits. A second category of content-neutral regulations happen when the government is attempting to regulate the secondary effects of particular speech. And the final category of content-neutral regulations occurs in situations where the government is not acting to regulate expression, but speech and conduct are mixed. Content-neutral regulations are treated to what's called intermediate scrutiny, and to pass intermediate scrutiny, a regulation must, 1, be justified without reference to the content of the speech, 2, be narrowly tailored to serve a significant government interest, and 3, leave open ample alternate channels of communication for speech or information at issue. Now, content-based regulations, on the other hand, regulate speech for that very reason, to control the content of what speech is being expressed in a particular forum. For hopefully obvious reasons, these regulations are treated with much more care. So much more care that they are presumptively unconstitutional, meaning that when a challenge is raised, the government must prove why this law does not violate the First Amendment, as opposed to the burden being on the challenger, which is typically the case. So in order to survive First Amendment challenge, content-based regulations must pass what's known as strict scrutiny. Strict scrutiny requires that the government show that the law or other government action is the least restrictive means of advancing a compelling government interest. And a law can be content-based in two ways, either on the face of the law or plainly within its text, or because of a discriminatory purpose. One example of a content-based action on its face is a law requiring manufacturers to include certain information on packaging labels. And an example of a content-based action with a discriminatory purpose is a prohibition against burning the American flag. And generally, the final thing that we need to consider when looking at First Amendment protections is what forum the speech is in. Courts have defined 4 categories of forums for First Amendment analysis. 1, traditional public forums, 2, designated public forums, 3, limited public forums, and 4, non-public forums. And those are ranked from lowest to highest in order of the government's ability to restrict free speech there. Now, with the highest protections, traditional public forums are defined as places which, by long tradition or by government fiat, have been devoted to assembly and debate. These 4 include places like sidewalks, streets, and public parks. And U.S. courts will allow content-based regulations of activity protected under the First Amendment in a traditional public forum only if the government can show its regulation is narrowly drawn to serve a compelling state interest and that it is narrowly drawn to achieve that end. Though time, place, and manner regulations are permitted in traditional public forums, as long as these regulations are narrowly tailored to serve a significant government interest and leave open ample alternate channels of communication. Now, a designated public forum is one which is created by purposeful government action when the government intentionally allows property to be used for public expression, even if not traditionally done. The central hallmark of a designated public forum is that it's required to be generally accessible to all speakers. The government is not required to establish these forums, but when they do, they are treated with the same scrutiny as traditional public forums. Examples of designated public forums are university meeting facilities and a city auditorium. Next, a limited public forum is one in which the government has expressly limited the subject matter and/or speaker allowed within the forum. Examples of limited public forums are a public school assembly hall after hours or a city hall meeting. And then finally, a non-public forum is one which is not by tradition or designation a forum for public communication. This could be the government space in which the government is acting as the manager of its internal operations, for example, the offices of government employees or military bases. So in both limited and non-public forums, government restrictions on speech will be permitted only if they are content neutral and reasonable in light of the purpose of the forum. So this is the framework for analyzing whether speech will be protected under the First Amendment. First, determining whether the activity is speech. Second, determining whether the government action in question is content-based or content-neutral. And 3, determining the forum of the speech and the restrictions that are taking place. Now, if your First Amendment rights are being violated, you'll want a good lawyer. But if you want a great lawyer, my law firm, the Eagle team, can help. If your loved one is suffering from mesothelioma, because asbestos exposure can take decades, if you've suffered a data breach, especially if you got one of those data breach letters, or were involved in a car crash, or just about anything else, we can help represent you or help find you the right attorney. It's so important to talk to a lawyer early in the process to learn what your options are and maximize your recovery. So just click on the link in the description or call the number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below. Now, there's also the wrinkle of free speech in public schools themselves. In 1969, the United States Supreme Court considered whether public school students retain their First Amendment right to free speech while they are at school in a case called Tinker versus Des Moines Independent Community School District. And the court answered this question in the affirmative, finding that the students did not leave their rights at the door. The protesting students in Tinker did so by wearing black armbands to school. The court found that behavior such as wearing armbands, t-shirts, or passing out leaflets was well covered under the protections of the First Amendment. And the court also established a standard to determine when protesting is within or outside the bounds of the First Amendment. This standard is that public school students are permitted to protest unless their protesting materially and substantially disrupts classes or other school activities. Now, private schools, on the other hand, aka schools which do not receive state or federal funding, are not governed by the First Amendment. This means that private school students do not have a First Amendment right while attending school or on school property. Though private schools typically have codes of conduct which regulate expression and student protests. And private schools must substantially comply with their published codes when they discipline students or faculty for speech or expression. So, does the First Amendment right to free speech protect the ability of UCLA protesters to stay on campus despite the forcible removal? Well, we don't have a full explanation of why the UCLA chancellor decided to declare the encampment illegal, but we can make some assumptions in our analysis. Well, first we need to consider whether the government action is content neutral or content based. UCLA framed the decision to declare the encampment illegal as a campus safety decision necessary for students, faculty, and public safety. And the government's intention behind the restriction matters. And in this case, at least the explicit intention was to increase public safety on campus. So assuming that to be true, the decision to close the encampment would probably be a content-neutral government action. And then we have to consider the forum in which the protest took place. The protest occurred in a public area of the UCLA campus, primarily on the steps of an auditorium hall. And this is a traditional public forum because the government has traditionally protected them for similar protests. And UCLA would likely be able to show that this action was justified without referencing the content of the speech. The violence that occurred posed a serious concern of continuing violence, and therefore the justification of protecting public safety would likely be sufficient in this case. Now, where UCLA might get into trouble is where they left open ample alternative channels of communication for the speech or information at issue. After the encampment was closed, protesters were arrested elsewhere on campus. UCLA has an obligation to maintain a speech for peaceful protest to speak, and it probably is not permitted to close all channels on campus. And similarly, under the right to assembly and the Tinker analysis, UCLA would probably be able to show that the encampment activities were materially and significantly disrupting class activities. Though it's not yet settled in federal court whether UCLA failed to meet a burden to protect their students during the encampment violence and whether their failure to do so affects the ability to later declare the encampment illegal. Now, in the Columbia University protest, the government action of forcibly removing the students from the campus buildings is likely also content neutral. The students were not removed because they were necessarily pro-Palestinian supporters. They were removed because they were occupying a college building. But for protests on the Columbia University campus, the analysis is a little different because Columbia is a private university. This means that Columbia students can't really claim First Amendment protections while on campus if they're being restricted by the college itself. Instead, Columbia students are only protected by the university published code of conduct. And the Columbia Code of Conduct makes this statement about freedom of speech and expression. Quote, "The university recognizes only two kinds of limitations on the right of freedom of expression, and both are to be narrowly construed. First, the university reasonably regulates the time, place, and manner of certain forms of public expression. Second, the university may restrict expression that constitutes a genuine threat of harassment, that unjustifiably invades an individual's privacy, or that falsely defames a specific individual." So while the law is different, the result is probably the same. In this instance, the university's action would likely be construed as a content-neutral time, place, and manner restriction, and the students were not removed because they were pro-Palestine supporters, they were removed because they had occupied a building. And while most of these First Amendment issues we've discussed have been fairly nuanced, there's one instance where the protesters really ought to have remembered the old adage, there's no free speech in the dean's backyard. Or at least that should be an old adage. You might have seen the videos of UC Berkeley students protesting at the home of Berkeley Law Dean Erwin Chemerinsky, and a private home, even when owned by a government official, is not a public forum of any kind. And even though the dean was holding a school-related dinner, it's likely that you're not going to have First Amendment rights within another person's private home. It shouldn't be surprising that you can't go into someone's private home, say what you want to say, and then claim your First Amendment rights are being violated if you're asked to leave. But that's not the end of the analysis, because not all protests are created equal, and not all responses are created equal either. When white nationalist Richard Spencer held a rally at Texas A&M in 2016, it triggered protests. In 2017, the university canceled Spencer's speech and decided that only campus-sanctioned groups could bring in outside speakers. In 2019, Texas lawmakers addressed this scenario by passing a law giving students more free speech rights on campus. But lawmakers were motivated by incidents like the one involving Spencer, where conservative speakers felt that they had been censored. So Senate Bill 18 prohibits universities from considering any anticipated controversy related to the event when approving guest speakers on campus. The Texas law recognizes that, quote, all persons may assemble peaceably on the campuses of institutions of higher education for expressive activities, including to listen to or observe the expressive activities of others. And the bill says the common outdoor areas of the institution's campus are deemed traditional public forums, as long as their conduct is not unlawful and does not materially and substantially disrupt the functioning of the institution. Now, this is a viewpoint-neutral law, and as written, it protects the right of students to protest outdoors in the common areas of campus as long as they don't disrupt the ability of the college to function. However, there was one viewpoint that Texas Governor Greg Abbott didn't really tolerate, and that was criticism of Israel. In 2017, Abbott signed a law prohibiting state contractors from boycotting Israel or expressing any viewpoint critical of Israel. The law was enjoined by a federal court because it violated the First Amendment. Then, in March of 2014, Governor Abbott issued Executive Order GA 44, which directed public universities to take action against speech that was anti-Semitic. And the order stated that universities must review and update free speech policies to address the sharp rise in anti-Semitic speech and acts on university campuses and establish appropriate punishments, including expulsion from the institution, ensure that policies were being enforced on campus and that groups such as the Palestine Solidarity Committee and Students for Justice in Palestine are disciplined for violating the policies, and include the definition of anti-Semitism adopted by the state of Texas in section 448.001 of the Texas Government Code in university free speech policies to guide university personnel and students on what constitutes anti-Semitic speech. And the executive order singled out particular words. Quote, multiple protests and walkouts have been staged by universities' student organizations, with students chanting anti-Semitic phrases such as from the river to the sea, Palestine will be free, which has long been used by Hamas supporters to call for the violent dismantling of the state of Israel and the destruction of the Jewish people who live there. And across Texas, public universities responded by banning the words in the executive order. Here's University of Texas San Antonio administrator warning the students not to chant from the river to the sea, Palestine will be free.
So the executive order states that language such as from the river to the sea is considered anti-Semitic speech. And so we're asking for folks to refrain from that because we are required to enforce that is not language that's used.
And she says that students who use those words would be referred to law enforcement. Not surprisingly, two student groups have now sued Governor Abbott, UT San Antonio, and the University of Houston, alleging that the executive order singles out pro-Palestinian organizations for punishment based on their political viewpoints. And the complaint references the video at UT San Antonio. Quote, at UTSA, plaintiffs spoke with a campus official who confirmed that it was UTSA's understanding that Governor Abbott's order forbids students from chanting from the river to the sea, Palestine will be free, during their protest. During a recording of that conversation between YDSA members and a UTSA campus official, a YDSA member asked what they can and cannot say. And the campus official states explicitly that they are not allowed to use the slogan because it was written specifically in the order. And that political slogan almost certainly doesn't constitute fighting words and is not a call for imminent lawless action, which means that it is a content-based regulation and is unlikely to withstand First Amendment scrutiny. But student protesters should be aware that their conduct might cross other lines. Federal prosecutors can charge a person with a hate crime for bias-motivated conduct under a variety of federal hate crime statutes. For example, 18 U.S.C. Section 245 makes it unlawful to willfully injure, intimidate, or interfere with any person or attempt to do so by force or threat of force because of that person's race, color, religion, or national origin, and because the person has been doing one of the following: enrolling in or attending public school or college, or participating in or enjoying a service, privilege, program, facility, or activity provided or administered by a state or local government. So, for example, in 2016, two University of Mississippi students pleaded guilty to violating Section 245 after they placed a noose around the neck of a statue of James Meredith. Meredith was the first black student to attend the university. This prosecution hinged on the student's admission that he, quote, knew the appearance of the rope and flag would be threatening and intimidating to African-American students. But you can see that sometimes the line between expressive conduct and threats and intimidation meant to specifically prevent people from taking certain action can sometimes get very blurry. And federal hate crime laws have been used to prosecute defendants who engage in prohibited conduct against people of various religious backgrounds and ethnic groups, including members of the Jewish and Islamic faiths. Though there has been a spike in anti-Semitism on college campuses, and there's also been calls to prosecute protesters who target Jewish students. In this video, protesters seem to block a Jewish student from entering the UCLA campus, and in this video, the protesters are blocking Jewish students from crossing a walkway.
I have my hands up. I'm not hurting them. I'm not hurting them. That's what they do. That's what they do, everybody. You guys are promoting aggression. You guys are promoting hate. We're UCLA students, we deserve to be there.
And here's a third video from UCLA which shows protesters refusing entry to any Jewish student who says they are a Zionist.
You guys want to prevent Jewish students from entering? Fine.
Now we got a couple Jewish students. Are you Zionist?
Yeah, of course I'm Zionist.
Yeah, we don't like Zionists in a thousand.
And we don't know if the Justice Department will prosecute anyone here, but there's certainly elements of the same kind of hate crimes that were prosecuted at the University of Mississippi. But students on both sides of this issue have said that they felt threatened by their classmates' speech. Now, speech that makes people feel threatened or disturbed might still be constitutionally sound, but there is an exception to the First Amendment for speech that incites imminent violence or lawlessness. But we generally don't want the government to persecute people because of their political speech. That's why it's hard to convict someone for inciting violence based on their opinions. And we've talked a lot about imminent lawless action on this channel, mostly in relation to Donald Trump's January 6th speech at the Ellipse. But Trump is not being prosecuted for giving this speech because it's really hard to prove that the speech incited a riot. And the current standard for imminent lawless action comes from Brandenburg versus Ohio, where the Supreme Court held that the Ku Klux Klan's First Amendment rights were violated by an Ohio criminal syndicalism law. And in Brandenburg, the court said that the government can only prohibit speech if it is, quote, directed at inciting or producing imminent lawless action, and it is, quote, likely to incite or produce such action. And that's a really high bar, and chanting political slogans usually doesn't cut it. Now, hate speech alone is still constitutionally protected, which is why some people think that chants like "from the river to the sea" constitute fighting words. Now, technically, fighting words aren't protected speech, but the Supreme Court has drastically limited the scope of fighting words because it's so hard to define which words really do provoke a violent response. But the classic definition is words that, by their very utterance, inflict injury or tend to incite an immediate breach of the peace. And generally speaking, even in highly charged protests, those kind of slogans don't qualify as fighting words, and thus still probably receive First Amendment protection. Now, on the other hand, a lot of these protests, whether they are peaceful or non-peaceful, have provoked quite a response from law enforcement. And we've talked a lot on this channel about excessive force by police officers. And in this context, there's probably a lot to choose from. Here's 65-year-old history professor Steve Tamari being body slammed to the ground by police while he was filming them at a protest at Washington University in St. Louis. And it's worth remembering that even if you disagree with a professor's message, police are still not entitled to use excessive force. And there are other indications that the police responses to some of these protests have gone too far. For example, at the University of Texas, Austin, police arrested 57 protesters for criminal trespass. A judge then dismissed all 57 charges because of a lack of probable cause. Probable cause is the legal justification that's necessary to charge someone with a crime, but according to the Texas Tribune, quote, those affidavits gave few details on each individual incident other than to state in various wording that each arrestee was told to disperse but did not. And the local prosecutor explained that the officers just hit copy and paste to fill out the arrest affidavits. And interestingly, the incident at Dean Erwin Chemerinsky's house involves all of these issues. As he wrote in The Atlantic before his annual dinner with students, flyers started appearing on campus. Quote, no dinner with Zionist Chem while Gaza starves. The poster declared in large letters. Students sometimes refer to me as Chem. It also included a caricature of me holding a bloody knife and fork with what appeared to be blood around my lips, an image that evokes the horrible anti-Semitic blood libel in which Jews are accused of killing and cannibalizing Gentile children. The poster attacks me for no apparent reason other than I am Jewish. The protesters did not specify anything I personally had said or done wrong. But Dean Chemerinsky allowed the poster to remain up on campus because he thought it was protected by the First Amendment. But again, a dean inviting students to his home does not make that home a public forum for protests. The news is so turbulent that many people are avoiding it altogether, but that can't be the solution. But there are ways to stay informed without feeling captive to the chaos. Luckily, today's sponsor, Ground News, is the solution. It's hard to capture just how different the experience of reading the news is on the Ground News platform. They give you a bird's eye view of the entire media landscape. So instead of being swirled around in it, you're outside looking at all the moving parts. The best example of this is the Ground News blind spot feed. Ground News uses patented technology to survey the media landscape and group together articles about the same topic. Then they organize them according to the political bent of the publication and highlight stories that are receiving a disproportionate amount of coverage from one side. What I love about this feature is I can anticipate what certain relatives who only watch Fox News are going to say when I go visit family. And that's what this is all about, right? Dunking on boomers. Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off of Ground News Vantage subscription by clicking on the link on screen or down below. This subscription gives you unlimited access to every feature, including the blind spot feed. And by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below. And after that, click on this link over here for more Legal Eagle, or I'll see you in court. It's a clearance sale on Clarence Thomas. According to a bombshell report from ProPublica, Supreme Court Justice Clarence Thomas has been secretly accepting gifts in the form of luxury vacation from billionaire Republican donor Harlan Crow and failed to disclose them for over 20 years. And a second ProPublica report revealed that one of Crow's companies purchased 2 vacant lots and a house from Thomas and his relatives in 2014, which Thomas also failed to disclose. Also, the home just happens to house one Leona Williams, Clarence Thomas's mom, who the billionaire donor has allowed to live there rent-free. And now a Washington Post investigation discovered that Thomas has for decades claimed income from a real estate company that no longer exists. The optics alone here are terrible. These luxury trips and real estate sales are potentially worth millions of dollars in benefits flowing from a conservative billionaire megadonor toward one of the 9 votes that have basically unchecked power over the whole US legal system. And Justice Thomas determined that he had no obligation to disclose any of this until he was caught. And frankly, upon examining the toothless ethics laws in place for our nation's top court and the apparent lack of political will to enforce the laws that we actually do have, Justice Thomas may be right. Now, before diving into the Clarence Thomas saga, let's talk about the key players here. First, we have the inheritor of a Dallas real estate fortune, Harlan Crow, who is a longtime megadonor to Republican candidates, causes, and organizations. Now, a few years after Justice Thomas joined the Supreme Court in 1991, Crow met Clarence Thomas and his wife, Ginny. And in the years that followed, they claimed to have become close friends, though importantly, in the years after he became a Supreme Court justice. Now, Crow is also a major donor to the Federalist Society, a conservative legal organization. Crow has publicly given more than $10 million in political contributions, and probably more via undisclosed dark money donations. But when asked about his contributions, Crow once told the New York Times that he, quote, does not disclose what I'm not required to disclose. Now, on April 6, 2023, ProPublica revealed that Clarence Thomas has accepted luxury trips nearly every year from Crow without listing them on his federal disclosure forms. In June of 2019, Justice Thomas and his wife Ginny flew on Crow's Bombardier Global 5000 jet to Indonesia, then boarded Crow's 162-foot super yacht for 9 days of island hopping. The total cost of the trip would have exceeded $500,000 had the Thomases chartered the plane and the fully staffed yacht themselves. According to the report, Thomas went on at least 6 trips on Crow's private jet, including to Indonesia, upstate New York, and New Haven, Connecticut. Thomas also traveled with Crow to the Bohemian Grove, an exclusive California all-male retreat, and visited Crow's ranch in East Texas. And 1 week per year, Thomas would vacation at Crow's private resort in the Adirondacks. And this is certainly much different from the more humble and down-to-earth image that Justice Thomas has attempted to cultivate over the years.
You know, I don't have any problem with going to Europe, but I prefer the United States. And I prefer seeing the regular parts of the United States. I prefer going across the rural areas. I prefer the RV parks. I prefer the Walmart parking lots to the beaches and things like that.
Yeah, sure. I'm sure that's the case. And just a week after the initial report on April 13th, ProPublica published details of an October 2014 real estate transaction between Crow and the Thomas family. According to public documents, one of Crow's companies paid just over $133,000 for 2 vacant lots and a single-family home that were co-owned by Thomas, his mother, and the family of Thomas's late brother. The transaction, which had not previously been disclosed, was the first known instance of money flowing directly from the Republican megadonor to a Supreme Court justice. Now, under the terms of the sale, Crow allowed Justice Thomas's then 85-year-old mother, Leona Williams, to live in her home for the rest of her life. She lives there currently rent-free, but is responsible for property taxes and insurance. And after the sale was completed, contractors then undertook extensive renovations of the house. Then, on top of those transactions, according to an April 16th article by the Washington Post, Thomas has reported hundreds of thousands of dollars of income from a firm called Ginger Limited Partnership for 2 decades. The problem here is that the real estate firm, founded by his wife and relatives, has not existed since 2006. The company's assets were taken over by a similarly named Ginger Holdings LLC, but Thomas's disclosure forms make no mention of a newer firm. Now, given the similarity of the names, it's possible that the company was just listed in error, but it merits mention given Thomas's decades-long history of non-disclosure. In a statement provided to ProPublica, Crow describes the Thomases as, quote, very dear friends, and defended the trips as the kind of hospitality he extends to all their close friends. Quote, we have been most fortunate to have a great life of many friends and financial success, and we've always placed a priority on spending time with our family and friends. With respect to the property purchase, Crow said he purchased the home with a plan to turn it into a public museum honoring Clarence Thomas. While he claimed the transaction was at market rate, Crow purchased a vacant lot and a house on the same block for $40,000 the prior year. Crow did not explain why he bought the 2 vacant lots, but indicated that they had been sold. Crow also asserted that he has never attempted to influence Justice Thomas on any legal or political issue, and claims he is unaware of any friends attempting to influence Thomas on the same. But at the same time, Crow serves on the board of multiple groups that have advocated at the Supreme Court through the filing of amicus briefs. And in 2005, a company called Trammell Crow Residential that was formed by Harlan Crow's father and partly owned by Harlan Crow was a defendant in a case before the Supreme Court. Clarence Thomas did not recuse himself from that case. In response to ProPublica's reporting, Clarence Thomas defended the trips and pleaded ignorance that it was wrong, and in a rare statement stated, quote, "Harlan and Kathy Crow are among our dearest friends, and we have been friends for over 25 years. As friends do, we have joined them on a number of family trips during the more than quarter century we have known them. Early in my tenure at the court, I sought guidance from my colleagues and others in the judiciary and was advised that this sort of personal hospitality from close personal friends who did not have business before the court was not reportable. I've endeavored to follow that counsel throughout my tenure and have always sought to comply with the disclosure guidelines. These guidelines are now being changed as the committee of the Judicial Conference responsible for financial disclosures for the entire federal judiciary just this past month announced new guidance, and it is, of course, my intent to follow this guidance in the future." Now, this statement raises far more questions than it answers. For example, while Thomas acknowledges being gifted family trips from Crow and perhaps others, he does not address the use of Crow's plane for other reasons, and as we'll talk about later, travel and the actual vacation itself are treated differently. For example, in 2016, Thomas used Crow's plane for a direct 3-hour trip to and from New Haven, Connecticut, which would have cost about $70,000. And it appears that Thomas might have been the only one on that plane. And obviously no one would ever vacation in New Haven, Connecticut, so the trip must have been for some other reason. Additionally, Thomas asserts that he sought guidance within the judiciary and was advised that his hospitality from close personal friends was not reportable. But Thomas doesn't specify who advised him, whether they had any expertise whatsoever, whether they were self-interested in that advice, whether this occurred before or after befriending Crow, or whether he followed up after this initial advice within the 30 years that this has been going on. And while Thomas claimed that he has always sought to comply with disclosure guidelines, the justice has a documented history of forgetting to disclose certain things. In 2011, Thomas amended prior forms to reflect income his wife earned between 1998 and 2003 from the Heritage Foundation, which is a conservative think tank, which Thomas claimed was inadvertently omitted. A 2004 LA Times report revealed that Thomas had accepted private plane trips and expensive gifts, including a Bible that was previously owned by Frederick Douglass, valued at $19,000, and a bust of Abraham Lincoln valued at $15,000. The article also noted that Crow had donated $175,000 for a new Clarence Thomas wing at the Justice's Childhood Library in Georgia. And after the Times report, Thomas continued to take plane trips from Crow. He just stopped disclosing them. And ProPublica is not the first publication to raise questions about the relationship between Crow and the Thomas family. In 2011, the New York Times detailed numerous favors that the Texas billionaire had done for the Thomases, including helping to finance a library dedicated to the Justice in Savannah, Georgia, and providing $500,000 for Ginny Thomas to start a Tea Party conservative activism group, which came with a $120,000 a year salary for Ginny Thomas. And in a move that stirred controversy at the time, Crow financed a multi-million-dollar restoration of a cannery that included a museum about the culture and history of Pinpoint, Georgia, a pet project of the Associate Justice. Now, Crow says he hasn't tried to influence Thomas on any issue, and it's true that people who are ideologically aligned are probably more likely to become friends. But if a billionaire gave my partner $500,000 to start a political organization, flew us around the world on a private jet, bought property from me that would both house my mother for the rest of her life, and promised to have that house turned into a museum honoring me, well, you might question the independence of this channel. Harlan, call me. Now, Thomas's former law clerk, James Ho, who currently sits on the Fifth Circuit Court of Appeals, defended his former boss by suggesting that the hypocritical double standards were at play, saying that, quote, "There's a big difference between actual corruption and the appearance of corruption." But even if there isn't any quid pro quo between Crow and Thomas, the entire crux of judicial ethics is based on avoiding any appearance of impropriety. But under 28 U.S. Code Section 455, any federal judge, including these Supreme Court justices, are supposed to recuse themselves from any proceeding, quote, "in which his or her impartiality might reasonably be questioned." Unfortunately, there are neither official rules nor a legal mechanism to force the justices to recuse themselves, and Chief Justice Roberts has long resisted calls to impose a code of ethics on the Supreme Court. And not surprisingly, there is a wide-ranging debate on this topic. Multiple legal experts told ProPublica that these non-disclosures were not just unethical, but may have broken the law, specifically the Ethics in Government Act of 1978. And in a bit of cheekiness from Congress, the Congressional Research Service put out a helpful explainer of this law following, quote, "a recent article detailing undisclosed trips by an associate justice." whoever that could be. Of course, as you may know, finding a great lawyer can be hard. That is, until now. My firm, the Eagle team, is now accepting new clients. If you've been injured in a car accident, medical malpractice, or just about anything, or you just need a lawyer, we can help represent you or find you the right attorney. Because you don't need a legal team, you need the Eagle team. Just check out the link in the description. Now back to Clarence Thomas's shenanigans. Now, the Ethics in Government Act, or EIGA, was passed in the aftermath of Watergate, in part to, quote, preserve and promote the integrity of public officials and institutions. To achieve this goal, EIGA established financial reporting requirements for many high-level government officials and employees, including Supreme Court justices. The Judicial Conference of the United States, the principal policy-making body for the federal courts, has authority under the EIGA to administer the financial disclosure requirements for judicial officers and employees. And under EIGA, the Attorney General is authorized to bring enforcement actions against any individuals who violate the law's disclosure requirements. Those who knowingly and willfully fail to file or report any required information face fines of up to $71,000 per omission, adjusted for inflation. And in addition, those who knowingly and willfully falsify information can face fines and up to a year in prison. Now, some have argued that Thomas did knowingly and willfully violate these statutes. Under the pertinent rules, disclosures must include the, quote, identity of the source and a brief description and the value of all gifts, while the Judicial Conference filing instructions say that all gifts over $415 must be disclosed. In addition, the failure to disclose the $133,000 sale of property from the Thomas family to Crow could also be a violation. Justices are required to report a brief description, the date and category of value of any purchase, sale, or exchange which exceeds $1,000 in real property. Now, there is a personal hospitality exemption to disclosure, which provides that any food, lodging, or entertainment received as personal hospitality of an individual need not be reported, but it's likely that parts of these trips might not fall under that exception. The Act defines personal hospitality as hospitality extended for a non-business purpose by an individual, not a corporation or organization, at the personal residence of that individual or the individual's family, or on property or facilities owned by that individual or the individual's family. Yacht and air travel are not food, lodging, or entertainment, and it seems that disclosure should have been required under the relevant acts. Though in March of 2023, the Judicial Conference clarified the contours of this exception, which the authors argue reinforced this reading. Quote, the personal hospitality gift reporting exemption applies only to food, lodging, or entertainment, and the reporting exemption does not include gifts other than food, lodging, or entertainment, such as transportation that substitutes for commercial transportation. Though a good lawyer would argue that if you have to clarify it, that's not the interpretation that existed before the clarification. And as luck would have it, we do have a fairly recent prosecution for failure to disclose under EIGA. In March of 2022, a federal judge ordered ex-Apprentice star turned Trump aide Omarosa Manigault Newman to pay $61,585 in civil penalties for knowingly and willfully violating EIGA for her acrimonious firing in 2017. In his 15-page opinion, Judge Richard Leon of the DC District Court found that Omarosa had received countless reminders from administration attorneys of her legal obligation to file a termination report financial disclosure within 30 days of being fired. And those arguing that Thomas knowingly and willfully failed to disclose past gifts point to the fact that in 1997, Thomas disclosed that Crow flew him to the Bohemian Grove on a private plane. That travel, along with Crow's history of lavishing Thomas with gifts, was reported by the LA Times in 2004, which drew lots of criticism. But for the next 20 years, Thomas apparently decided to keep accepting flights from Crow, but just didn't report it anymore. So Thomas's statement that he received advice telling him that he didn't have to report plane and yacht trips doesn't really comport with the fact that he used to disclose this information, but then chose not to. Now, many observers have unfavorably compared Thomas's example to that of Justice Abe Fortas, who ended up resigning from the Supreme Court in 1969 after his own payment scandal. In 1968, LBJ nominated Justice Fortas to succeed Earl Warren as the Chief Justice. But an investigation revealed that Fortas had been paid $15,000 to be an adjunct professor at American University. But funding came from some of Fortas's old firm and clients, some of which came before the court. Fortas would later request to withdraw his nomination, but opted to stay on the court. But in 1969, it was revealed that Fortas took a $20,000 retainer from the family foundation of an indicted securities swindler, Lewis Wolfson. President Nixon, hoping to fill a liberal Supreme Court seat with a conservative, began leaking information to the press to pressure Fortas to resign. Now, Fortas's conduct was not technically illegal at the time, but Chief Justice and Fortas's friend, Justice Hugo Black, urged Fortas to resign to protect the integrity of the court. Reluctantly, Fortas resigned, and Republican Nixon got his wish. But don't expect Clarence Thomas to resign anytime soon. But the question remains, who can launch an investigation into the Supreme Court? Well, by law, the DOJ may initiate an investigation on its own or at the request of the Judicial Conference. Democratic Senator Sheldon Whitehouse of Rhode Island and Representative Hank Johnson of Georgia have sent a letter requesting the Judicial Conference investigate, writing, quote, "There is at least reasonable cause to believe that Justice Thomas intentionally disregarded the disclosure requirement by not reporting the 2014 property sales to Crow." But there's not a lot of examples of the Judicial Conference making such referrals, nor the DOJ prosecuting them. In 2014, the Judicial Conference referred Judge Boyce Martin, a Carter appointee to the Sixth Circuit, to the DOJ's Public Integrity Unit to investigate allegations of improper travel reimbursements. But the department decided not to pursue charges after Judge Martin, who had retired in 2013, voluntarily repaid the $138,000 he had received as travel reimbursements during the contested 4-year period, even though he said only a fraction had been challenged. Okay, it's Devin from the future, and there's been a lot of new developments. So much so that I moved things around in my set, so it looks slightly different now. Now, Clarence Thomas has not denied any of the facts in the ProPublica article, and Thomas's defenders assert that the whole story is nothing more than a smear campaign by bitter Democrats. Though it should be noted that some of Thomas's public defenders have also accepted money and fancy trips from Harlan Crow. For example, over at the National Review, lawyer Mark Paoletta wrote a story with the following headline: "Justice Thomas acted properly and was not required to disclose his trips." Seems totally legit. Though I should warn you that the article includes a world-class disclaimer. Full disclosure, I worked on Justice Thomas's confirmation as a lawyer in the White House in 1991. I have co-edited a book on him titled Created Equal, Clarence Thomas in His Own Words, and remain close friends with him. I have also represented Ginny Thomas in the January 6th committee inquiry. Now, a disclaimer to the disclaimer, this doesn't even tell the full story of his relationship with Thomas and Crow. Paoletta worked on the confirmations of Justices Thomas, Gorsuch, and Kavanaugh, and oh yeah, he was also a guest with Harlan Crow on the very same trips as Thomas himself. Here he is with Justice Thomas at Camp Topridge in the painting commemorating one of those vacations. Truly a masterful painting that really captures the essence of the photograph, which was also taken of the exact same spot. And it also captures the delicate light reflecting off of Harlan Crow's calves. But Paoletta's argument is that Thomas wasn't required to disclose the vacations because the personal hospitality requirement is brand new. And in an equally baffling follow-up piece, Paoletta addresses the sale of the house that Thomas's mother lived in. The crux of the argument is this, quote, "In the years preceding this transaction, Justice Thomas and his wife put significant sums of money into making improvements to his mother's house. Given these costs, their 1/3 share of its sale price amounted to a capital loss on the property. Because of that, Justice Thomas did not believe that the sale of his mother's home was a reportable transaction. This is, without exaggeration, insane. The relevant statute, as you've seen, requires disclosure of, quote, any sale which exceeds $1,000 in real property other than the property used solely as a personal residence of the reporting individual or the individual's spouse. It makes no distinction between whether the sale was for a profit or loss. It kind of makes you question Thomas's ability to understand, the law. Meanwhile, Justice John Roberts turned down a request to testify in front of the Senate about the unreported gifts, travel, and real estate transactions. Instead, he sent a letter stating that the justices are all ethical. All 9 justices signed a document attached to the letter entitled Statement of Ethics, Principles, and Practices. Roberts suggested that there was a separation of powers issue with asking the Chief Justice to appear before the Senate. He points out that only 2 justices and 3 presidents have ever done so. Though it does make one wonder what kind of checks and balances there are if the Supreme Court can't be forced to testify in the face of potentially huge corruption. And as the Chief Justice acknowledges, testimony of justices and presidents is rare but not unheard of. The 2 justices who testified to Congress in the past were questioned about administrative matters. So the Chief Justice implies that it's fine to go to the Senate to talk about minor issues, but it's somehow beyond the pale for the Chief Judge to address serious ethical issues. Now, obviously the justices fear additional embarrassing disclosures. For example, 9 days after his confirmation, Justice Neil Gorsuch sold a property that had languished on the market for 2 years. He disclosed the sale, but left the buyer section blank. The buyer turned out to be the leader of a law firm with, surprise, many cases in front of the Supreme Court. Now, these accusations have come out against Clarence Thomas, but they'd be astounding if any justice had committed them. And of course, these are only the facts that we know about. For all we know, Justice Sotomayor might be being flown around the world by Bill Gates, and Kagan is getting hundreds of thousands of dollars of vacations from Larry Ellison. And all of that would be super bad. But the lack of ethics or enforcement is a real problem with no easy solution. There are real separation of powers issues, and the Supreme Court interprets the law. And also Congress is pretty much deadlocked on everything, so it's not likely that any of this is likely to change anytime soon. And Paoletta stepped up again to defend Thomas when reports came out that Crow paid for the private schooling of his grandnephew. Reports state that Thomas took on his grandnephew, became his guardian, and raised him as a son. All extremely laudable things. But he didn't disclose that Crow had paid over $150,000 for the boy's private school tuition. This time, though, Paoletta seems to have a better defense for Thomas. Paoletta argues, and I think he's right this time, that the relevant statute requires disclosure of gifts for dependent children, but defines dependent children as a son, daughter, stepson, or stepdaughter, and who is a dependent defined by the IRS. No idea why the statute is written that way, but it seems true that Thomas's grandnephew is not a son, daughter, stepson, or stepdaughter, and thus this particular incident wouldn't need to be reported. There are reports that Justice Sonia Sotomayor was paid $3.6 million for various book deals, but declined to recuse herself from multiple copyright infringement cases involving book publishers or their parents or subsidiaries. Now, that's bad too, but at least she disclosed those issues where Thomas seems to have hidden his incidents completely. Of course, the justices really enjoy their privacy. So if you'd like to be as private as a Supreme Court justice, you can get your online personal data taken down with today's sponsor, Incogni. Now, I don't know about you, but I've seen a huge uptick in the amount of spam that I'm getting. And it's no surprise. Every year, the number and scope of data breaches worldwide is rising. And you might not know it, but there are hundreds of data brokers that possess and sell your personal data, probably right now, and their numbers are growing every year. These data brokers could have your name, your address, phone number, shopping habits, possibly even your social security number, all up for the highest bidder. I know when I checked, there were literally hundreds of different companies that had this information. At best, this leads to scam calls, and at the worst, identity theft and doxing. But here's where Incogni comes in. Incogni fights on your behalf to remove your personal data from data brokers and deals with any objections from their side. All you have to do is create an account and give them your approval to work on your behalf. Incogni conducts repeated, ongoing removals because even if the broker removes your data once, they could collect it again. Incogni makes sure that your personal information stays off the market for good. When I signed up, I saw a huge decrease in the number of spam emails and calls that I was getting. And it was terrifying to see exactly how many brokers have our data, and it's really fun to watch Incogni get them to delete that info one by one. If they fight, Incogni will actually fight back and send repeated letters on your behalf until that information is gone. So if you'd like to give Incogni a try, click on the link below to get 60% off of Incogni when you use the code LegalEagle. Again, to get 60% off, just click on the link that's on screen right now or down in the description and use the code LegalEagle. And after that, click on this box over here for more LegalEagle, or I'll see you in court. Trump has been gagged multiple times by the court. Yes, as soon as multiple gag orders had been issued, it seemed like Trump has violated them, and that's gonna be a whole thing. And I know we did a whole video on how Trump was claiming he was under a gag order when he wasn't. Well, now the gag orders are really coming down. U.S. District Judge Tanya Chutkan has heard enough, and after a 2-hour hearing about Donald Trump's habit of calling prosecutors and witnesses liars, thugs, and traitors, the judge has issued an order barring him from making any public statements targeting witnesses, lawyers, and court staff. Now, the order applies to all parties, but so far only one of them has been suggesting that some witness kinda sorta maybe should have been executed, and that person is Donald Trump. Judge Chutkan said Trump can, quote, assert his belief that this prosecution is politically motivated, but his, quote, First Amendment freedoms do not allow him to launch a pretrial smear campaign. So of course Trump quickly exercised his free speech rights and blasted the order.
I'll be the only politician in history that runs with a gag order where I'm not allowed to criticize people. Can you imagine this? Do you believe this? I'm not allowed to criticize people, so we'll see. We'll appeal it, and we'll see, but it's so unconstitutional.
Now, after the Justice Department indicted Trump in DC, Trump vented on Truth Social, if you go after me, I'm coming after you. Now, there are obviously many ways that you can interpret that statement. Trump did not identify anyone by name, nor was it even clear his comment was about the DC case. He could have been talking about any of the people on his enemies list, such as Barack Obama, Hillary Clinton, or the editors who dropped him from the Forbes 400 list. However, the government contends that Trump was obviously talking about the DC prosecution. Special counsel Jack Smith said Trump subsequently, quote, made good on his threat by making inflammatory comments about the case on an almost daily basis. For example, Trump described Judge Chutkan as a biased Trump-hating judge who deserves a filthy and crime-ridden district that is over 95% anti-Trump. He also posted derogatory things about Bill Barr and Mike Pence. So Smith filed a motion asking the court to stop Donald Trump from making public statements attacking the citizens of the District of Columbia, the court, prosecutors, and prospective witnesses. Prosecutors said that, quote, Trump's relentless public posts marshaling anger and mistrust in the justice system have already influenced the public. For instance, on August 5th, 2023, police arrested Abigail Jo Schrei for making, quote, racist death threats to Judge Chutkan. The government also said that jurors are already fearful of blowback by angry Trump supporters, citing the criminal trial of Brandon Fellows, a Trump supporter who was at the Capitol on January 6. You might recall that during the trial, the jury sent the court a note expressing concern that Fellows might have information about the identity of jurors. But naturally, Trump opposed the motion. He argued that a gag order would be a prior restraint on political speech that would violate his First Amendment rights. Quote, the Biden administration charged President Trump, the leading contender in the 2024 presidential election, for statements he made as president. Now, keenly aware that it is losing the race for 2024, the prosecution seeks to unconstitutionally silence President Trump's, but not President Biden's, political speech on pain of contempt. And Trump argued that the court has less draconian tools to ensure a fair trial, including a change of venue, postponement of the trial, extensive searching of prospective jurors, and sequestration of the jurors as well. Those are arguably less restrictive options than the blanket protective order. And Trump wasn't wrong. Americans have First Amendment rights to freedom of speech, and criminal defendants have a constitutional right to a fair trial. And you don't give up those rights even when you're accused of 90-something crimes.
I got 99 problems, but if
Judge
ain't one, hit me.
But there are scenarios where a person's right to a fair trial can be in conflict with someone else's free speech rights. If there is too much commentary about a case, it can taint the jury pool. Now, this is a fairly underdeveloped part of constitutional law because criminal defendants rarely have such a burning desire to make pre-trial statements, as well as the means to fight the court when they issue these types of orders. But the Supreme Court has held that judges can limit attorney speech when a lawyer's words have a substantial likelihood of materially prejudicing a legal proceeding. In Gentile versus State Bar of Nevada, the court said that attorneys aren't entitled to the same degree of protection as the media. But what if a person is making incendiary statements as a criminal defendant? Well, the Supreme Court has never explained which standard applies to the speech of a criminal defendant, let alone the standard that applies to a person running for president. In Trump's case, the government argued that the court should apply the standard articulated in Gentile versus State Bar of Nevada, while Trump argued that the Gentile standard only applies to lawyers. Trump contended any speech restrictions on defendants must survive strict scrutiny, meaning that the government must prove that any prohibited speech would constitute a clear and present danger to the administration of justice. At the hearing, Judge Chutkan announced that she would sidestep the issue of the proper standard. She said, quote, I intend for any order I issue to meet to satisfy either test. Now, as you can probably tell, Trump is going to need a good lawyer to fight all these gag orders. But if you want a great lawyer, my firm, the Eagle team, can help. If you've had an injury or death in the family, suffered a data breach, or were involved in a car crash, we can represent you or help find you the right attorney who can. Because getting a lawyer right away is so important to make sure you get a full recovery. Just click on the link in the description for a free consultation with my team. Because you don't just need a legal team, you need the Eagle team. The link is down below. Now back to all the gag orders. But different courts have different rules. In Trump's New York hush money case, Judge Juan Manuel Merkin issued a protective order preventing Trump from publicly discussing the evidence disclosed during the discovery process. The order also prevents Trump from receiving the names or other identifying information about people who work for prosecutor Alvin Bragg, other than prosecutors and law enforcement members, until the start of jury selection. However, Judge Merkin refused to characterize this as a gag order. He said he would not impose a gag order because, quote, such restraints are the most serious and least tolerable on First Amendment rights. That does apply doubly to Mr. Trump because he is a candidate for the presidency of the United States. In Merkin's view, the government would need to show that Trump's speech presented a clear and present danger before he would restrict it. In Trump's New York civil trial, Judge Arthur Engoron issued a limited gag order after Trump posted a photo of the judge's clerk with Chuck Schumer along with a link to her private Instagram profile. But Judge Engoron was not amused. He said, quote, consider the statement a gag order forbidding all parties from posting on social media about members of his staff. Judge Engoron did not limit Trump from speaking about the judge, though. In Washington, D.C., the local federal court rules are stricter. In order to avoid interfering with a fair trial or prejudicing the administration of justice, Rule 57.7 prohibits anyone from making a public statement about, quote, the identity, testimony, or credibility of prospective witnesses, and any opinion as to the accused guilt or innocence, or as to the merits of the case or the evidence in the case. If the case is a widely publicized or sensational criminal case, the court, on motion of either party or its own motion, may issue a special order governing such matters as extrajudicial statements by parties, witnesses, and attorneys likely to interfere with the rights of the accused to a fair trial by an impartial jury, the seating and conduct in the courtroom of spectators and news media representatives, the management and sequestration of jurors and witnesses, and other matters which the court may deem appropriate for inclusion in such an order. Trump ally Roger Stone ran afoul of this rule when he posted a photograph of Judge Amy Berman Jackson with crosshairs superimposed over her image. The judge said Stone was trying to, quote, gin up more public comment and controversy about the legitimacy of the Mueller investigation, the House investigation, and to get people to question the legitimacy of the prosecution. She concluded that Stone was acting in a manner that would pose a substantial likelihood of material prejudice. Now, the gag order hearing in front of Judge Chutkan went about as well as you might expect. The judge went through several of Trump's statements, asking both sides to comment about whether Trump's comments interfered with a fair trial or prejudiced the administration of justice or the credibility of witnesses. Judge Chutkan was most concerned about whether Trump's statements about the judicial system and its employees violated local rules. She said she was aware of and did not care about what Trump said about her, but she was appalled by Trump's comments about Judge Engoron's clerk. She wanted to know if John Lauro, Trump's attorney, agreed that such statements were out of bounds. Lauro said he would advise Trump that such comments were a bad idea, but he also argued that, quote, nothing has happened like that in this case, and nothing like that will happen. Judge Chutkan was skeptical. Lauro said there's no need for an order because when a judge or lawyer tells Trump to do something, he does it. Quote, because if Your Honor makes that kind of admonition, it will be followed, and it has been followed. Lauro really did say that, but without cameras in the courtroom, I don't know if he said that with his straight face. Judge Chutkan asked Lauro about the things that Trump said about Bill Barr and Mike Pence, and Trump posted a video attacking Barr for not helping him overturn the election and criticized Pence for not throwing out electoral votes.
Why does Fox News constantly put on slow-thinking and lethargic Bill Barr, who didn't have the courage or stamina to fight the radical left lunatics?
And she also wanted Lauro to address Trump's September 22nd comment about Joint Chiefs of Staff General Mark Milley. Trump said, quote, this guy turned out to be a woke train wreck who, if the fake news reporting is correct, was actually dealing with China to give them a heads up on thinking of the President of the United States. This is an act so egregious that in times gone by, the punishment would have been death. Lauro said that Trump's commentary about Milley, Pence, and Barr is acceptable because, quote, none of them have ever suggested that the criticism of President Trump has led to any diminution of their ability to do their jobs or testify or do whatever they want to do in terms of criticizing President Trump. Just the opposite, they give as good as they take. Judge Chutkan disagreed. Quote, that's right up to, would no one rid me of this meddlesome priest? If you suggest that someone is deserving of execution, that's not a far stretch to imagine a situation where one of the millions of followers of this person decides to go ahead and do that. Laura responded by saying she hit the nail on the head and brought up the time that a deranged Bernie Sanders supporter shot Steve Scalise, which really is not exactly the point that he was trying to make there. Lauro said that the gag order proposed by the government would mean that Trump couldn't truly campaign against Joe Biden, but even under the government's proposed order, the prosecutor conceded that Trump wouldn't be barred from attacking Joe Biden or Joe Biden's Justice Department. But the government didn't totally have its way during this hearing. The prosecution sought a very broad gag order that would have undermined Trump's ability to challenge the prosecutions as politically motivated. The DOJ wanted to bar Trump from making any derogatory statements about the Department of Justice or Merrick Garland. Judge Chutkan was reluctant to impose a restriction on Trump's ability to challenge his prosecution by the DOJ. Quote, it seems awfully close to his right to assert his innocence and criticize the government. And the Supreme Court emphasized in Gentile that speech critical of the exercise of the state's power lies at the very center of the First Amendment. And while the government tried to persuade Judge Chutkan that Trump's attacks on the city would somehow prejudice the jury pool, she disagreed. Quote, this is not about whether I like the language Mr. Trump uses. This is about language that presents a danger to the administration of justice. So after a 2-hour hearing on the motion, Judge Chutkan issued an order granting the motion in part and denying the motion in part. Quote, in order to safeguard the integrity of the proceedings, it is necessary to impose certain restrictions on public statements by interested parties. Undisputed testimony cited by the government demonstrates that when defendant has publicly attacked individuals, including on matters related to this case, those individuals are consequently threatened and harassed. The judge found that Trump went beyond merely criticizing the judicial process. He crossed the line by stating that, quote, particular individuals involved in it are liars or thugs or deserve death. The court finds that such statements pose a significant and immediate risk that 1, witnesses will be intimidated or otherwise unduly influenced by the prospect of being themselves targeted for harassment or threats. 2, attorneys, public servants, and other court staff will themselves become targets for threats and harassment. And that risk is largely irreversible in the age of the internet. Once an individual is publicly targeted, even revoking the offending statement may not abate the subsequent threats, harassment, or other intimidating effects during the pretrial as well as trial stages of this case. The judge rejected Trump's contention that the court can't limit his speech because he's running for president. Quote, the bottom line is that equal justice under the law requires the equal treatment of criminal defendants. Defendants' presidential candidacy cannot excuse statements that would otherwise intolerably jeopardize these proceedings. And her order applies to all parties to the case, not just Donald Trump, though In fairness, it's only going to affect one person. It limits that person or people from making public statements that target prosecutors, defense counsel, the court, staff, and any reasonably foreseeable witnesses or the substance of their testimony. But the judge did allow criticism of herself. And accordingly, Judge Chutkan ordered, quote, all interested parties in this matter, including the parties and their counsel, are prohibited from making any public statements or directing others to make any public statements that target 1, the special counsel prosecuting this case or his staff, 2, defense counsel or their staff, 3, any of the court staff or other supporting personnel, or 4, any reasonably foreseeable witness or the substance of their testimony. Now, that is a gag order, but it's not a total gag order. Trump is not prohibited from maintaining his innocence, describing his prosecution as politically motivated, or criticizing the government. Now, if a judge finds the defendant has disobeyed an order of the court, the person can be found in criminal contempt. And criminal contempt can carry a penalty of days in jail, thousands of dollars in fines, or both. The court can also impose stricter orders and fines. A person in violation of a court's order can have their bail revoked, meaning that would put the person in custody until trial. That's what happened to Sam Bankman-Fried, who was under house arrest while awaiting trial. Prosecutors said that Bankman-Fried tried to intimidate former FTX CEO Caroline Ellison by publicly sharing her diaries. And he allegedly also tried to contact FTX General Counsel Ryan Miller over email and the encrypted messaging platform Signal, which violated the judge's conditions of release. So the judge in that case revoked his bail. But if you're anticipating that Trump would be put behind bars for violating any of these gag orders, you probably should lower your expectations. Given the circumstances of these cases, I wouldn't expect that to happen unless it was the most extreme of circumstances. And judges know that keeping Trump from making disparaging remarks is playing a game of whack-a-mole. But courts do have other options to coax him into compliance. For example, Judge Chutkan previously suggested that if Trump cannot follow the court's orders, she will bump up the March trial date. And it's likely that Trump doesn't want any of his trials to happen before the 2024 election. And at the hearing, John Lauro told Judge Chutkan that she could avoid the First Amendment issues by postponing the trial until after the general election. She brushed off that suggestion because it's probably the strongest tool she has to get Trump to comply. But of course, as soon as these gag orders were issued, it seems that they were violated. We're now getting a look at just how hard it is to coordinate a presidential campaign during a trial. On October 20th, the New York Attorney General alerted Judge Engoron that Trump had failed to remove a post about the judge's law clerk from his campaign website. Judge Engoron said, quote, I learned that the subject offending post was never removed from donaldjtrump.com and in fact has been on the website for the past 17 days. Incendiary untruths can and have led to serious physical harm. I will now allow the defendant to explain why this should not end up with serious sanctions or I could possibly imprison him. He asked Trump lawyer Chris Kise why Trump shouldn't face serious sanctions, and Kise said it was just an accident. Trump had deleted the post from his social media accounts, but it was still on the campaign website. And after a brief recess, Trump's lawyers told the judge that nobody really saw the post. Trump's lawyers said that the campaign sent emails to roughly 25,000 recipients, but only around 6,700 of those messages were opened. But Judge Engoron was not amused. He fined Trump $5,000, but warned Trump not to do it again. Trump was, quote, way beyond the warning stage. But since Trump was a first-time offender, he felt that it was only appropriate to fine Trump a nominal amount. And Trump quickly gave Judge Engoron another opportunity to ramp up his fines. On the day Michael Cohen was testifying in the civil case, Trump offered these comments.
If we had a jury, it would have been fair, at least, even if it was a somewhat negative jury, because no negative jury would vote against me. But this judge will, because this judge is a very partisan judge, with a person who's very partisan sitting alongside of him.
When the judge found out about these remarks, he assumed they were directed at the judge's clerk, a clear violation of the order. Judge Engoron said, quote, it's very easy for the public to know who that person is. I'm very protective of my staff, as I believe I should be. I don't want anybody to be killed. And then the judge asked Trump's lawyers why there should not be severe sanctions for this blatant, dangerous disobeyal of a clear court order. Chris Kise said Trump was obviously talking about Michael Cohen, not the court clerk. Kise said that the context was that Cohen was partisan. This seemed dubious because Trump wasn't discussing the substance of Cohen's testimony and Cohen was not sitting next to him. It seemed clear Trump was referring to how the court was administering the case, that this is a bench trial instead of a jury trial, and that the judge and his clerk were Trump haters, and the clerk is the one that was sitting close to the judge. The judge tabled discussion of the matter until after the lunch break when Trump agreed to take the witness stand where he was put under oath. Judge Engoron asked Trump who he was referring to, and Trump said, you and Cohen. The judge said, quote, "First of all, my principal law clerk is very close to me. You and I can see each other, and we are close, but not as close. And there's a barrier between us, so wouldn't that at least be somewhat ambiguous as to whom you are referring?" Trump didn't back off of his claim that he was referring to Cohen, which was probably smart on his part. But the judge said, quote, "As the trier of fact, I find that the witness is not credible," and he fined Trump $10,000. Now, again, this fine is small in Trump's world, but the overall finding is a big deal. The judge, who's going to render a verdict in this case, found that Trump lied to his face. Other judges will probably take note, as will the special counsel. And speaking of Judge Chutkan's case, Trump appealed the gag order to the DC Circuit of Appeals, where he asked for an emergency stay pending appeal. Trump's lawyers also asked Judge Chutkan to stay her gag order while they prepared a full appeal, and Judge Chutkan issued an administrative stay of her own order. Now, the gist of Trump's appeal is that the order is unconstitutional because it limits his right to engage in core political speech. Trump argues that the part of the order restricting comments about Barr, Milley, and Pence is unconstitutional. Quote, "The witnesses that third parties listening to President Trump have supposedly intimidated, former Vice President Pence, former Attorney General Barr, and former Chairman of the Joint Chiefs of Staff, Mark Milley, are extremely high-level public figures who have voluntarily entered the public arena and invited the cut and thrust of public debate by openly criticizing President Trump. Thus, the prosecution's speculation that these witnesses will be, quote, intimidated by President Trump's criticism is non-credible on its face." And Trump claims that the government should have produced affidavits from these witnesses attesting that they've faced intimidation and harassment. And these are not crazy arguments. Trump got support from the ACLU, which probably hasn't happened all that many times before, which filed a brief supporting Trump. Anthony Romero, director of the ACLU, said, quote, "If we allow his free speech rights to be abridged, we know that other unpopular voices, even ones we agree with, will also be silenced. As much as we disagreed with Donald Trump's policies, everyone is entitled to the same First Amendment protections against gag orders that are too broad and too vague." The ACLU argues that the word targeting in the judge's order is also too vague. Quote, "In the context of the order, it could mean something as innocuous as name or identify or something much more violent. One could target another with respectful but vigorous political advocacy or target them for physical violence or death." The ACLU agreed that there is a serious risk that Trump's words can inspire other people to violence, but it contends that the mere fact that others have threatened actions against trial participants after hearing defendants' words is not enough. Of course, surprising no one, after Judge Chutkan stayed the order, Trump wasted no time in resuming his commentary on witnesses and prosecutors. Here he is describing Jack Smith as deranged in a way that would have violated the original order. In the same post, he attacked Anthony Pratt, an Australian businessman who says Trump shared classified information with him at Mar-a-Lago. And Trump also commented on Sidney Powell's guilty plea, clarifying that while she was never his attorney, she did a, quote, valiant job of representing a very unfairly treated and governmentally abused General Mike Flynn. Which is interesting because Powell took a plea deal and is now expected to offer testimony against Trump in the Fulton County case and could be a witness in the case that Judge Chutkan is presiding over in Washington, D.C. So Judge Chutkan has a conundrum on her hands. Trump's team will brief the court on freedom of speech issues and prosecutors will respond. But it's anyone's guess what will happen next. Judge Chutkan could invalidate the original gag order and issue a more narrowly tailored gag order, which could create a whole nother set of appeals, or maybe not, because it might be so narrowly tailored that it's not worth fighting over. Or she could let the original appeal play out. But Trump is wasting no time in issuing a ton of statements that probably violate the original now stayed gag order. Trump's comments include calling Jack Smith deranged. He comments on the substance of Mark Meadows' alleged testimony and has been lashing out at cooperating witnesses as weaklings and cowards. But Trump's gag order has been covered extensively by more than 190 different news outlets, and 29% of the reporting is coming from the left and 21% is coming from the right. And if you compare the headlines, you'll start to see some interesting frames emerge. On the left, you have outlets using terminology like imposed, ordered, and prohibits with reference to the gag order, while on the right, you'll find outlets using words like slapped with or hits. Those word changes are subtle, but they play a big role in how readers perceive the story. The first set of words might imply authority and precedent, while the second set of words might imply something unfair or immature. And all this is possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. At Ground News, every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings by 3 independent news monitoring organizations. I especially like the Ground News comparison feature, which highlights specific differences between left and right reporting. For the story on Trump's gag order, you can see the left-leaning outlets tend to focus on Trump's legal team opposing the gag order, while the right focuses on statements by Trump calling the indictments election interference and a witch hunt. Now, Ground News also has a blind spot feed, which highlights stories that are disproportionately covered by one side of the political spectrum. This kind of analysis is so important so we don't live in an echo chamber or get misled by subtle and sometimes not so subtle language in the news. So give Ground News a try by clicking on the link that's on screen right now. Ground News is giving LegalEagle viewers 30% off their Vantage plan. This includes access to a feature called My News Bias, which is basically a dashboard for your news diet. You can find out your top news sources, whether you're engaging with diverse perspectives, and what your favorite topics are. So you can try it out by going to ground.news/LegalEagle or click on the link that's on screen right now or down in the description. You can get started for less than $6 a month and support an independent news platform working to make the media landscape more transparent. And after that, click on this link over here for more LegalEagle, or I'll see you in court. Yes, Logan Paul has sued CoffeeZilla for saying mean things about his crypto scams. Hey Logan, I'm gonna say some mean things about you. You wanna dance? But who could have possibly have seen that Logan Paul's crypto ventures might not be on the up and up? I mean, you'd need at least one eye for that. But to take you back, he promised that his game, Crypto Zoo, which combined cryptocurrency and NFTs, would allow users to make real money with barely any effort.
It's a really fun game that makes you money. I really, really do believe it is going to be the catalyst for a lot of young people getting into crypto. I think this will be their first fun NFT crypto experience. My game.
Now, it's possible that Crypto Zoo might have made Logan Paul some real-world money with very little effort, but players who purchased the in-game currency were left out in the cold. But that's where YouTuber CoffeeZilla, real name Steven Findezen, comes in. He's been investigating Paul's promises and the demise of Crypto Zoo since at least 2022, calling Paul out for being a scammer. And now Logan Paul has filed a defamation lawsuit against CoffeeZilla. Paul alleges that he maliciously and repeatedly published false statements accusing Paul of operating a scam related to Crypto Zoo, and that these lies have hurt his reputation, caused him significant emotional distress. Logan Paul was just an upstanding internet citizen who completely rehabilitated his image, and then CoffeeZilla just came out of nowhere and ruined that good name. But first, what is Crypto Zoo? Well, Crypto Zoo was a Pokemon-inspired trading game where users could buy eggs, hatch them, and then breed the animals. To participate, users spend their non-fungible tokens, called Zoo Coins, to buy the eggs. The app runs on the Binance Smart Chain, and the NFTs are purchased with Ethereum. The game promised users that they could make real money this way. All you had to do was breed very rare digital hybrid animals and then watch your cache of coins grow.
Bro, we have a massive team behind it and are probably out of pocket like $1 million just because we believe it's going to work.
It was a simpler time back then, and the sales pitch worked. Players purchased over $2.5 million worth of digital eggs, which helped create enough hype to convince the crypto market that the Zoo Coin's actual value was worth up to $2 billion. But here's the catch. Crypto Zoo launched in September of 2021, but as of 2024, it's still not fully playable. Players who purchased the eggs couldn't breed them, let alone cash out the coins for real money, and investors said that the eggs were just a picture on a screen that was basically worth nothing whatsoever. And that's a pretty accurate description of an NFT. It took me and Steve Bold 27 minutes to say the same thing a few years ago. But the Crypto Zoo development team left the project in October of 2021, alleging that, quote, Logan's team has stolen the tokens from all of its V3 investors, while also lying to the public that he had paid the devs $1 million. Now, while it's not unusual for a group of people to have creative differences, Paul's silence and the lack of playable game led many people to believe that they'd been conned. In December of 2022, CoffeeZilla started a 3-part series on Crypto Zoo. At first, Paul responded by blaming a developer who fled to Switzerland with the source code and held it hostage for $1 million. However, CoffeeZilla tracked down this developer, Zach Kelling, who disputed everything Paul said about him. And reporters also discovered that Paul's other partner on the project, Eddie Ibanez, was a catch-me-if-you-can level liar. Paul's manager, Jeff Levin, allegedly knew about Ibanez's exaggerations before the Crypto Zoo launch, but kept him on the team. Now, Logan Paul filed his lawsuit in federal court in the United States District Court for the Western District of Texas, though Logan Paul putatively lives in Puerto Rico and CoffeeZilla and his company reside in Texas. Although many defamation complaints are filed in state court, filing in Texas federal court gives Logan Paul an advantage because CoffeeZilla won't be able to use the Texas anti-SLAPP law. As you might know, a strategic lawsuit against public participation, or SLAPP suit, is a legal action intended to censor, intimidate, or silence critics by burdening them with the cost of legal defense. And the Texas Citizens Participation Act, or TCPA, allows defendants to file a motion to dismiss a legal action that infringes on their right to free speech. This motion can be filed early and often before the case proceeds to discovery, which saves a huge amount of money. However, CoffeeZilla won't be able to use the TCPA to file an early motion to dismiss and recover costs because the Fifth Circuit, which rules over Texas, ruled that the state law doesn't apply in federal court. Parenthetically, I'll note that there's a circuit split where some federal courts will apply state-based anti-SLAPP laws and some will not. which is why we need a federal anti-slap law. So without an applicable anti-slap law, CoffeeZilla's defense is going to get extremely expensive, even if he's successful. But let's look at Logan Paul's lawsuit. Paul's complaint alleges that CoffeeZilla's commentary about CryptoZoo perpetuates a false narrative that CryptoZoo was a scam orchestrated by Paul. He says that CoffeeZilla knew he was making false statements when he published the videos. So what are the allegedly false and defamatory statements? Well, it started with the December 2022 YouTube series. Right off the bat, in response to those videos, Paul threatened to sue CoffeeZilla. In a now deleted video, Paul said, quote,
"You led the charge to drive and monetize a narrative telling millions of people that I'm a fraud or I tried to scam my audience. That is patently false."
And Paul accused CoffeeZilla of not reaching out to him to get the facts until December 24th, 2022. On Twitter, CoffeeZilla said he contacted Paul in October seeking clarification about the CryptoZoo project, and you can see his questions for Paul on the Instagram post. And these messages went unanswered. And at the time, Paul swiftly backed down. Then CoffeeZilla tweeted, quote, "Logan called me, he said he's deleting the 2 responses and is dropping the lawsuit threats." CoffeeZilla had planned to release another video about CryptoZoo, but decided to delay the video so he could include Paul's response. And here was Logan Paul's later response, saying the war is not with coffee, and quote, "I'm grateful he brought this to light." He apologized and promised to come up with a plan to make things right. CoffeeZilla warned Paul that he would continue to follow the CryptoZoo story, saying the quote, "The right thing to do here is refunds for the affected victims. That's what this has always been about." Now, there's no actionable defamation in these old exchanges since Logan Paul acknowledges what CoffeeZilla reported was true, and they're also outside of the 1-year statute of limitations for bringing libel claims in Texas. But that's where things get interesting because Logan Paul announced a 3-step plan to remedy the problem.
So I'd like to announce my 3-step plan moving forward. Step 1, Jeff and I are going to burn our Zoo tokens so we have no financial upside in the game and it will add value to holder tokens. Step 2, we want to offer a rewards program for players who are disappointed in the status of the game. So essentially you're going to be able to burn your base egg or your base animal for the mint price, which was 0.1 ETH or the equivalent in BNB. I am personally committing 1,000 ETH to this, which is about $1.3 million right now for players who want to get out. And then step 3, obviously finish and deliver the game.
Now, Paul made promises to remedy the situation, but not everyone was happy. So some of the customers sued him and they went to arbitration, where they were represented by attorney Tom Kirker, who you might know by his online moniker, Attorney Tom. Now, put a pin in that, we're gonna come back to it. But fast forward 6 months later when CoffeeZilla tweeted out, "Logan Paul really is the type of dude to thank you when you expose his scam, then block you when you remind him to pay up." Now, Logan Paul alleges that CoffeeZilla's tweet is libel per se. A defamation or libel per se describes statements which are considered to be so harmful on their face that the plaintiff doesn't need to prove special damages, that they can get by with basically no damages and still file suit. In Texas, defamation per se includes accusing someone of having an infectious disease, accusing someone of a crime, or making statements that harm someone in their job or profession. Now, in this context, the allegation of defamation per se probably doesn't make any difference whatsoever. But in general, to prove defamation, he has to show 1, the publication of a false statement of fact, 2, that was defamatory concerning the plaintiff, and 3, that the person made the statement with actual malice, and 4, damages. And I'll remind you that the term actual malice is a legal term of art. It does not mean that the publication of false statements was made with mean intention, but rather that the plaintiff has to actually know that what they're saying is false or act with reckless disregard for the truth of that statement. And here Logan Paul alleges that, quote, "The accusation that Paul operated a financial scam is one that tends to harm his reputation so as to lower him in the estimation of the community or deter third persons from associating or dealing with him." The June 29th, 2023 X post is libelous per se, and that it tends to affect Paul in his profession or occupation and accuse Paul of engaging in illegal conduct. Now, according to Texas law, a statement constitutes defamation per se if it injures a person in his office, profession, or occupation, but this is interpreted narrowly so it doesn't prohibit legitimate complaints against a person for their professional conduct. And generally, disparagement of a general character equally discernible to all persons is not enough unless the particular quality of disparagement is of such a character that it is peculiarly valuable in the plaintiff's business or profession. Now, what is Logan Paul's profession? Arguably an influencer or boxer. He's not a developer, he's not a financial professional, nor does he have any special knowledge of NFTs and how the blockchain works, clearly. So really, even if it mattered here, the allegation of defamation per se probably wouldn't apply anyway. But anyway, Logan Paul says by 2023, CoffeeZilla knew that CryptoZoo wasn't a scam. He says, quote, "The post was a gross and intentional distortion of Paul's prior statements in which he referenced CoffeeZilla's research as a positive in the sense that it had helped expose the wrongdoing by Paul's former business partners, who had also hoodwinked and victimized Paul. Feinstein knew this, but he intentionally conveyed to the public the false accusation that Paul was a participant in a scam and intentionally defrauded people to increase his own profile by continuing to attack a well-known celebrity." And Logan Paul cites the mean tweets as proof that his reputation was ruined by CoffeeZilla's scam comment, but number one, he would have a very hard time proving damages, But more to the point, there's little evidence to support the claim that CoffeeZilla's characterizations were false in the first place. There was no completed game, his fans weren't paid back, and CoffeeZilla discovered that the people that Logan Paul was working with had lied. Not to mention, this seems to be a classic opinion based on disclosed facts about the type of person that Paul is. In fact, they all seem to agree on the underlying facts that CryptoZoo was in fact a scam. The only difference is that Logan Paul is claiming that he was also a victim of bad developers as well, and CoffeeZilla says that when you put your name on something and you run the whole project, the reputation is yours. Logan Paul doesn't like the implication, but you can't force your opinion onto someone else. In fact, CoffeeZilla could probably write another tweet saying that Logan Paul is the type of person to sue you for defamation when you exercise your First Amendment rights. Moreover, to the extent that the tweet is factual, it seems accurate. Logan Paul has blocked CoffeeZilla for years. He hasn't paid back all of his customers, so, where's the lie? Additionally, on June 30th, 2023, CoffeeZilla published a video entitled Logan Paul's Scam Isn't Over. Logan Paul alleges that this video is defamation per se, again, objecting to the characterization of CryptoZoo as a scam. He says CoffeeZilla, quote, left no doubt that he was accusing Paul of intentionally defrauding individuals who bought egg NFTs or Zoo tokens by referring to those people as his, Logan Paul's, victims, declaring to his audience that Paul was guilty and his offer to reimburse buyers of egg NFTs was an admission of guilt, and stating that Paul was just pretending he'd changed. This video has been viewed nearly 6 million times, and I highly recommend watching it again so it can be viewed 6,000,001 times. So, did CoffeeZilla make false claims about Logan Paul in this video? Well, the point of the video was, quote, Logan Paul promised $1.8 million to the affected victims, saying, in the meantime, I have committed more than $1.8 million for those who do not want to wait for CryptoZoo to be completed. However, despite bragging about making millions with Prime, there have been no updates about the status of these updates. Now, Logan Paul says that CoffeeZilla was, quote, aware at the time of the publication that these statements were false, or at a minimum had a high degree of awareness that the statements were probably false. But we can look to the video. Here's Logan Paul complaining that CoffeeZilla reached out to his manager rather than him personally.
Maybe we could have talked about this if you had reached out to me, personally. Not my manager, Jeff, who is not me, Steven.
But when CoffeeZilla reached out to Paul, he heard back from Paul's lawyer.
Well, I did reach out to you, and I got no response. In fact, the only response I got came on my 4th attempt to reach Logan, but this one came from his criminal defense lawyers. A guy named Jeffrey Neiman emailed me after my 4th attempt saying, Steven, see inserted on behalf of Logan Paul. Now, to be honest, I had no idea who Logan Paul was until I researched the lawyer and learned that he, quote, regularly defends individuals and corporations in white-collar criminal litigations. And that's when I realized, oh, that Logan Paul. Why didn't you just say you defended alleged white-collar criminals? Would have saved me a Google search. So I opened up the letter and it read, we represent Logan Paul. Mr. Paul has informed us of your outreach about the status of the CryptoZoo buybacks. Mr. Paul remains committed to this process. We are working with Mr. Paul to evaluate the best way to achieve this goal. In the meantime, please direct to our attention any further inquiries to Mr. Paul. Thank you for your patience and understanding. Now, that might seem like a good step in the right direction to you. At least we got a response on behalf of Logan.
And as CoffeeZilla points out, there are two things absent from the lawyer's statement.
But when I read their response carefully, I realized things were actually worse than I thought. Because two things are absent from this statement. One, a timeline for refunds, and two, a plan for refunds. I mean, you have this abominable statement which says, we are working with Mr. Paul to evaluate the best way to achieve this goal? So you're still at the whiteboard then? Guys, this is a statement you say when you have no plan or you're stalling, right? You say, we're evaluating the best options. I mean, that's where Logan was back in January. He was evaluating. Am I supposed to believe 6 months later, you guys haven't figured this out? You've gathered all the boys in the office, brainstorming every single day. How do we refund people? And you don't know?
Now, recall that we talked about how Logan Paul is currently being sued in real life by Tom Kirker, attorney Tom, in arbitration, and they're seeking damages caused by Paul's crypto venture. But perhaps the most shocking thing about this whole thing is that Logan Paul's lawsuit, the complaint, actually admits a whole bunch of the stuff that attorney Tom was going to have to prove for that case, which is one of the reasons you should never file performative lawsuits in the first place. Even though it's the right thing to do, not filing a performative lawsuit, you should do it for self-interested reasons. Here, it'll very likely prejudice the defense of his case against the accusations in the other arbitration. Moreover, the whole complaint basically admits that CryptoZoo was broken beyond belief, which most people would qualify as a scam, but Logan Paul just claims to be a victim of his own developers. Now, it's not dispositive, but Merriam-Webster defines a scam as a fraudulent or deceptive act or operation. Paul committed $1.8 million to pay people back, but for some reason after 6 months, he never followed through on his 3-step plan. Though, in fairness, since there is a whole bunch of pending litigation, that might be the reason why he hasn't taken remedial steps. You need to figure all that out before you can start paying out millions of dollars. But still, one is allowed to have the opinion that by not paying off the victims, that you're simply perpetuating a scam. Here's CoffeeZilla reading from the post where Paul outlined what he would do.
I mean, listen, he had more of a plan, Logan did, back in January. I'm not even sure what there is to even still figure out, because way back then, January 16th, he said, I've committed more than 1.8 million. For those who do not want to wait for CryptoZoo to be completed, players will be able to burn their base eggs and base animals for their mint price. I mean, there it is. That's the plan. Pay a blockchain dev to code that up and pay the victims their money. That's it.
This video also calls Paul out for not explaining himself for the delay in paying people back. And I can't fathom that there's anything false here. Many people were wondering about their refunds, but Logan Paul wasn't responding to them, leading them to conclude that he was being deceptive when he made the promises. Again, people are allowed to have their opinions based on the disclosed facts. And even CoffeeZilla predicted that Logan Paul would eventually claim that he had to be silent because he was a defendant in a lawsuit.
Only he's tried this before, and it didn't make a lot of sense then either.
I had to rely on my team. I crumbled internally, and the advice was, while actual legal process was going on because of criminal investigation taking place that CoffeeZilla highlighted in his series, I had to stay silent. And for a year, I'm hounding Jeff. How do we make this right?
So at base, CoffeeZilla is going to have two probably pretty good defenses. First, these comments are 100% true. And second, they form the basis of his legally protected opinion, which is that Paul is a scammer because he cheated his fans out of millions of dollars. And then finally, Paul's third claim is that a January 5th, 2024 YouTube video called Logan Paul's Refund, CoffeeZilla accused Paul of orchestrating a massive con, referred to Paul as a serial scammer, and claimed that Paul scammed those who bought Zoo tokens or CryptoZoo egg NFTs.
It is still 100% within Logan Paul's power as a near billionaire with Prime to make things right, fully right, with his fans who he scammed.
On January 4th, 2024, Paul officially announced on X that his CryptoZoo egg NFT buyback program was operational. He posted a link to a website where holders could submit a claim for buyback, with Paul committing up to $2.3 million of his own money to the effort. And on that same day, Paul sued Ibanez and Greenbaum, alleging that they'd scammed Paul and he relied on their advice. Now, CoffeeZilla's January 5th video was published one day after Paul sued the developers and finally made a refund offer. Paul claims that since CoffeeZilla had many of the documents and text messages Paul cited in his lawsuit, that any characterization of Paul as a con or a scammer is false and defamatory. But CoffeeZilla's video explains that Logan Paul's refund offer came with a bunch of strings. He was offering up to $2.3 million, but the estimated damages are more than $18 million, and anyone who accepts the refund must waive their legal rights to participate in the lawsuit filed by attorney Tom or in any other legal action against Paul.
Logan may be losing. Put in that light then, this refund starts to look less like a good faith attempt to make things right and more like a cynical bargaining chip to avoid getting in even more trouble.
Now, I don't know if Logan Paul is acting in good faith, but CoffeeZilla is perfectly entitled to that opinion. And there's no way to prove that factually, in Logan's brain, he had good intentions all along, including when his lawyers made a settlement offer. But CoffeeZilla certainly has plenty of reasons for concluding that there was a con and a scam. And as he points out in the video, he watched Logan's fans beg for a refund for 3 years.
But I was wrong. I mean, I wasn't wrong the first time he said I was wrong when he said he was going to still finish the game. I was wrong that he was going to do it at all.
But even after 12 months of work, you've still managed to overlook one crucial piece of information. See, even though I've said it's coming so many times, you've assumed that CryptoZoo isn't being made. Who are you to decide when the development timeline ends? Trust me, CryptoZoo is coming. I will make damn sure of it.
Oops, so much for making damn sure of it, because there's no game.
And despite hemming and hawing about the game, Logan Paul didn't actually finish the CryptoZoo game. And ironically, the lawsuit that Logan Paul filed against the developers made good use of CoffeeZilla's investigations and videos about Ibanez's background and Greenberg's secret sales of tokens.
Turns out Eddie Ibanez's entire backstory was a fabrication, including the MIT NFL story. Can you believe it? It's like, yeah, we know. And then he goes, yeah, well, you won't believe what I discovered. Crypto King secretly sold tokens. Yeah. We know. Logan just shamelessly rips off my work claim for claim without citing me. I mean, he says things like, Mr. Greenbaum would later admit that he made millions of dollars through his surreptitious sales of zoo tokens. But where did Logan find that admission? Was it perhaps when he investigated my video? Time and time again, this lawsuit copies my work, but is embarrassed to cite it. So they even have to say things like, based on public reports. What public report? Mr. Ibanez made approximately $1.7 million from selling zoo tokens. I could swear I've heard that before. And for my calculations, he made about $1.7 million.
So Logan Paul has sued CoffeeZilla for making false statements because he keeps repeating facts that Paul has acknowledged in his own lawsuit against the developers are true. But Logan Paul just doesn't like how CoffeeZilla has characterized these facts. Now, sure, Logan Paul wants people to look at these same facts and conclude that he had positive intentions and that he got taken advantage of the bad guys. And maybe you do, but you're also welcome to conclude that Logan Paul is a serial scammer, because two people can draw different conclusions from the same facts and it doesn't qualify as defamation. And while things that are labeled as opinion can sometimes give rise to defamation, they still need to be a verifiable fact. And there's actually case law applying the word scam in the context of a cryptocurrency scheme. And courts have decided that using the word scam in the context of a cryptocurrency scheme is generally not a verifiable fact that can be proved true or false. But even if you could, it would still qualify as an opinion. And that makes sense. We call things scams all the time when there's an outcome that we don't necessarily like. Logan Paul asserts that you can only use the word scam to describe something where they intentionally intended something to steal money from someone, but that just doesn't jive with the regular definition of scam that we use all the time. Though it might actually apply in this case too. We don't know. Now, Logan Paul's lawsuit seeks compensatory damages for the harm to his reputation, emotional distress, and punitive damages, and an injunction to prevent CoffeeZilla from continuing to report on CryptoZoo. But the bottom line is that Logan Paul filed this lawsuit because he wants to silence his main critic. And that's the very definition of a slap suit. And even though CoffeeZilla won't be able to use the TCPA, he still has every other defense to a defamation lawsuit, including his statements are true facts, and also his own opinions. The First Amendment also protects rhetorical hyperbole, which is how we describe exaggerated over-the-top speech employed for rhetorical effect. And frankly, even if these statements were defamatory, Paul would probably struggle to prove damages. Now, so far, CoffeeZilla hasn't said anything publicly, which is very smart. He's hired some great attorneys, and it looks like he'll let them do the talking, which, again, is smart, because when it comes to IRL legal disputes, the shit gets real. Now, as far as I know, CoffeeZilla has not started a GoFundMe or a campaign to recoup any of his legal defense costs, and those can get astronomically expensive. Ethan Klein of H3H3 incurred hundreds of thousands of dollars in a fair use dispute, and that was 10 years ago. But the next best thing would be to support CoffeeZilla on Patreon, which is where he gets most of his funding anyway. I'll put a link to CoffeeZilla's Patreon in the description of this video. I highly recommend becoming a member of CoffeeZilla's Patreon and contributing what you can. CoffeeZilla does great work, and it would be a real shame to let someone like Logan Paul silence CoffeeZilla. And in fact, I did a little digging and found that CoffeeZilla is actually represented by some very good attorneys. In fact, if you've been watching this channel for a while, you might actually have heard of them, because CoffeeZilla has retained Mark Bankston and Bill Ogden over at Farrer and Ball. They have been spearheading much of the defamation litigation against Alex Jones and are responsible for the approximately $50 million verdict for the Texas plaintiffs against Jones. And Bankston in particular is responsible for what might be the cross-examination of the decade, when he created the Perry Mason moment, when he crossed Alex Jones on the stand and caught him in a lie after Jones's attorney accidentally sent Bankston the contents of Jones's phone. We talked about that at the time. It was an epic and textbook cross-examination skewering. So CoffeeZilla is in pretty good hands. But don't take it from me, I reached out to CoffeeZilla's lawyers and got Mark Bankston on the phone. Mark, thanks for being here. You are actually representing CoffeeZilla, is that correct?
No, that's correct. My partner Bill Ogden and I have agreed to represent CoffeeZilla in this very exciting suit.
You know, in the world of online lawyers, there's a whole spectrum of people that are qualified and that are not. Quick perusal of your resume seems to indicate that you guys know your way around defamation.
Yeah, most folks are probably aware of my defamation practice through the lawsuits that I brought against Alex Jones and InfoWars on behalf of several Sandy Hook parents. This situation is used on a different foot. This will actually be the first time that we are defending someone from a defamation suit, but it is something we very strongly believe in this particular case.
What has happened so far?
Right now, very little has happened. There hasn't been an answer in the suit or anything like that. You would usually, in most states at this point, face an anti-slap motion. That type of motion is not available in federal court in the Fifth Circuit in Texas. In this case, the federal court venue was chosen And there seems to be no obvious reason for that except to avoid the anti-slap motion. Ironically, this is a very, very vicious attack on CoffeeZilla's reputation that really he has no way to vindicate except going in the court and winning on this suit.
Reading the complaint, I was very surprised that Logan Paul had completely rehabilitated his image, and then CoffeeZilla just came out of nowhere and besmirched him for no reason whatsoever. So I found that to be very surprising.
Yeah, it seems far-fetched. I guess we'll have to see where discovery takes us on that. Definitely. I mean, look, you can look at this suit, and it has all of the hallmarks of a classic slap suit. There's not a single person on this planet who can look at the situation and say that CoffeeZilla knew and intended to tell lies about Logan Paul. You know, I think I knew it before he became my client. I think I know it way more now. If there's something that man cares about, it's the truth. He is devoted to that principle, like very few journalists that I see today. This case really presents a David and Goliath type problem. You look at somebody like CoffeeZilla, yes, he has a lot of YouTube subscribers. I mean, I'm sure he makes money. You know, I'm sure he does fine. He's not anywhere near the capacity of his opponent. I mean, his opponent has an unlimited war chest to come at him and could essentially use this suit to drive him off the internet. We're not going to let that happen.
So in terms of next steps, I would assume there would be a motion to dismiss based on the allegations of the complaint, or maybe if you wanted to get feisty, pre-answer discovery. I don't know if that's available.
Absolutely. I mean, look, you can't look at that complaint and not think judgment on the pleadings. I mean, that's just what you think the moment you see it. Are the statements being made even something that can be verified as true or false? What does it mean to call something a scam? The word scam can be interpreted a lot of different ways, and it does not mean one thing to all people. Businesses and bad deals are described as scams constantly.
This is not the only suit that Logan Paul is in related to the crypto scheme. He's currently facing other lawsuits related to the nature of that. And it seemed to me that a lot of those allegations are going to be deleterious for the litigation that he's in outside of this particular case.
The thing that I kept thinking to myself is that if I'm any one of those claimants in those cases, I'm extremely interested in the things that were said in this complaint. And as a result, going to be very interested in how this lawsuit progresses. All right, dude. Thanks for having me. I'll talk to you soon.
Thanks a lot. Take care. But even with great lawyers, lawsuits are still stressful, and it's easy to lose your appetite. Unless you use today's sponsor, Factor. Because Factor makes meeting your nutrition goals easier than ever by delivering fresh, never frozen, dietitian-approved meals right to your doorstep. And the meals are completely ready to eat in just 2 minutes. You can eliminate the hours it would take to shop, meal prep, and cook, so you can spend your day doing the things that you actually want to do. You can choose from over 35 different options a week, including ones that are keto, calorie smart, vegan, and veggie, and more. And on top of that, Factor offers lots of snack options for when you don't feel like a full meal, like breakfast smoothies, juices, small bites, and more, just to keep going no matter what's on the schedule. And Factor meals arrive at your door pre-prepared and ready to eat in just 2 minutes. In the same amount of time that I can even think about going to the grocery store, my Factor meal is already done. Which is great because sometimes I just want a good, healthy meal without having to cook. And it's surprisingly affordable as well. Way less expensive than takeout and those pricey delivery apps. And now Factor offers Gourmet Plus meals as part of your weekly options, so you can try meals that feature premium ingredients like filet mignon, shrimp, truffle butter, broccolini, and asparagus. But honestly, you can't go wrong with their normal offerings either. Factor's team of gourmet chefs creates each meal to help you feel your best all day long, and they really are extremely delicious. And Factor is completely flexible. You can pause or reschedule your deliveries at any time. But all this is making me hungry, so click on the link below or the one that's on screen and use the code LegalEagle50 to get 50% off your first Factor box and 20% off your next month of orders. Again, just click on the link below and use the code LegalEagle50 for 50% off your first Factor box and then 20% off your next month of orders. And after that, click on this box over here for more Legal Eagle, or I'll see you in court. Did you know that it's illegal not to pay Elon Musk money? Yes, when a billionaire buys a social media platform, the law says you must advertise on that platform. Even if you're not an advertiser, you have to find a way to advertise. This is due to a little-known provision of the Communications Decency Act. I'm sorry, I don't make the rules, but this is America, where we absolutely love compelled speech. Okay, all of that was completely untrue, but what is true is that Elon Musk has declared war on advertisers because they hurt his feelings. We tried being nice for 2 years and got nothing but empty words. Now it's war. Musk, who is a self-described champion of free speech and free markets, previously told advertisers that if they didn't like the new regime, they could GTFO.
If somebody's going to try to blackmail me with advertising, blackmail me with money, go f yourself.
But that was, of course, 8 long months ago, and Musk didn't anticipate that all the advertisers would just pick up their ball and go home. Now Musk believes it's totally illegal for a business not to give him money. Musk and Twitter sued the Global Alliance for Responsible Media, or GARM, a coalition of advertisers for violating antitrust laws by coordinating with brands to discourage advertising on Twitter. Twitter CEO Linda Yaccarino, wearing a pendant around her neck that says free speech, released a statement in support of the lawsuit.
I was shocked by the evidence uncovered by the House Judiciary Committee that a group of companies organized a systematic illegal boycott against X. It is just wrong.
Now, I'd like to assume that this video was generated by Twitter AI because I don't think a human could be that robotic, but I actually don't think that AI could be as robotic as Linda Yaccarino is in that particular video. But why should Twitter's users care about an advertiser boycott? Because
they conspire to boycott X, which threatens our ability to thrive in the future.
That is Yaccarino speak for, oh crap, we're not making enough ad revenue to pay the interest on the $12.5 billion loan that we took out. But make no mistake, Yaccarino says that the advertisers are actually coming after Twitter users, and now everyone who uses the platform is in danger.
These organizations targeted our company and you, our users.
Now, Twitter users might be in danger, but it's not because they aren't getting any more ads for Snickers. As Media Matters discovered, after Musk took over, advertisements from big brands started appearing next to, quote, content that touts Adolf Hitler and his Nazi party. Musk and Yaccarino took prompt action to deal with that problem by, suing Media Matters. And apparently the next step in wooing these advertisers back is apparently suing them. When Elon Musk purchased Twitter back in 2022, he promised to make it a beacon for free speech. And as we pointed out at the time, he also bought himself a bunch of different lawsuits. And he was critical of Twitter's moderation policies, which he claimed were overly restrictive and unfairly penalized conservatives. And as we also pointed out at the time, this made absolutely zero sense because the founder of Twitter, Jack Dorsey, was basically a free speech absolutist, and the moderation policies were probably there for the bottom line. These were Chesterton fences that existed for a very good reason. Musk just didn't understand why. So Musk reinstated the accounts of controversial people like Andrew Tate and Donald Trump, and removed the block function, which allowed users to block content they didn't want to see. Predictably, once Musk made those changes, there was a huge increase in racial slurs and anti-trans rhetoric. And of course, Musk wanted to get in on the fun himself, and has publicly supported racist and anti-Semitic tweets, like this one which blames Jews for causing the Great Replacement, a horribly racist double whammy. Or this video he posted which also lays out the Great Replacement theory.
1. Flood the country with untold millions of illegals by land, sea, and air from all over the world. Enough to eclipse the populations of 36 individual US states so far.
And even if you're the most cynical company in the world who only wants to make money, and you can stomach all the awful stuff that Musk is doing, you probably still don't want your company's ads running next to tweets with the hashtag white power.
I joined X because I believe in the power of the global town square.
And this kind of thing was happening to IBM, Disney, Apple, and lots of other big companies. And Musk apparently forgot that corporations and individuals have free speech rights protected by the First Amendment, and that includes who they associate with or choose not to associate with. So when Musk's idiosyncratic interpretation of free speech, which basically says no one should have any consequences from speech, when that backfired, he hired Linda Yaccarino to reassure advertisers that the platform would not host harmful or offensive content. Yet every time Yaccarino made a little headway in winning back advertisers, Musk would reinstate another banned account or make some incendiary comment. So for example, on November 15th, 2023, a Twitter user accused Jewish people of pushing, quote, hatred against whites that they claim to want people to stop using against them. Musk replied, "You speak the actual truth." This sparked another advertiser boycott. 200 advertisers, including Disney, Apple, and IBM, froze their advertising on the platform. Yaccarino responded by claiming that, quote, X has been extremely clear about our efforts to combat anti-Semitism and discrimination. There's absolutely no place for it anywhere in the world. Well, it was clear there was no place for it except on her boss's Twitter account. And so Yaccarino and Musk decided to be introspective and take responsibility for the consequences of their actions. No, I'm just kidding. They decided to sue the advertisers themselves. Twitter sued the World Federation of Advertisers, the WFA, and a bunch of big advertisers, including Unilever, Mars, CVS, and Orsted. Musk alleges that they violated the Sherman Antitrust Act by conspiring together to tank the platform. And Twitter filed its lawsuit in the United States District Court for the Northern District of Texas, Wichita Falls Division, which is where most of the damages occurred. I'm just kidding. It's blatant venue shopping. We'll talk about that in a second. But Musk coordinated his attack with Ohio Republican Jim Jordan and right-wing social media platform Rumble. Last month, the House Judiciary Committee, led by Jordan, released a report called GARM Exposed. House Judiciary report says ad coalition likely broke law to silence conservatives. And Rumble filed a lawsuit against GARM that's basically a cut-and-paste version of the Twitter lawsuit. And what do you know? It was also filed in the Wichita Falls division. But why is one of the largest companies in the world suing other multinational corporations in Wichita Falls? Judge shopping, of course. As Steve Vladeck observed, the lawsuit has, quote, a 100% chance of being assigned to Judge Reed O'Connor, and that's what Musk wants. Appointed to the Northern District of Texas by President George W. Bush in 2007, O'Connor's resume includes a 2018 ruling throwing out the entire Affordable Care Act on grounds that were derided as insanity on print. And Judge O'Connor has already helped Musk out. Early this year, we did a video about how Twitter was filing a slap suit against the liberal media watchdog Media Matters. And while most judges would have swiftly dismissed this case on First Amendment grounds, O'Connor has kept the suit alive. Fortunately for Media Matters, the Supreme Court often reverses Judge O'Connor, but the harassment through litigation is meant to chill speech and drain the resources of the defendants, and on that score, Musk has been pretty successful. Media Matters has already laid off 14 staffers and spent millions of dollars, and just 2 days after this lawsuit was filed, GARM announced that it would dissolve. Quote, while the World Federation of Advertisers denied that GARM's work had run afoul of the law, it said that the nonprofit did not have the financial resources to continue operating while it fights X in court. Now, obviously, if you're filing a bunch of slap suits, you'd probably want a good lawyer, not a Kraken wannabe. But if you want a great lawyer, my law firm, the Eagle Team, can help. If you've suffered a data breach, especially if you got a data breach letter saying that your social security number has been leaked, were involved in a car crash, or dealt with sexual harassment, we can represent you or help find you the right attorney. Because it's so important to talk to a lawyer right away so you can get the best representation and find out what your options are. So just click on the link in the description or call the phone number that's on screen for a free consultation with my team. Because you don't just need a legal team, you need the Eagle Team, so click below. But the WFA is a global association that represents over 150 of the world's biggest brands and more than 60 national advertisers associations worldwide. And the WFA started a group called the Global Alliance of Responsible Media, or GARM. And according to the WFA's website, GARM was, quote, a voluntary cross-industry initiative created in 2019 to address digital safety. GARM was set up in the wake of the Christchurch, New Zealand mosque shootings, during which the killer live-streamed the attack on Facebook. This followed a slew of high-profile cases where brands' ads appeared next to illegal or harmful content, such as promoting terrorism or child pornography, creating both consumer and reputational issues for brands. GARM's purpose was to set standards these companies could look to when they evaluated social media platforms. And although Twitter quit GARM after Musk took over, the company rejoined GARM in July, just a month before filing the lawsuit. And according to the complaint, when Musk purchased Twitter, GARM encouraged advertisers not to work with the platform. Quote, between November 2022 and December 2022, at least 18 GARM member advertisers stopped purchasing advertising from Twitter either in the United States or worldwide. Dozens more stopped advertising in 2023, in many instances by over 70%. This had a massive impact on Twitter's revenue. Quote, last year, X lost about 52% of its US advertising revenue, which dropped to $1.13 billion. The lawsuit alleges that even when the price of the advertising on X was lower than X's social media competitors, the advertisers did not return to Twitter. And if you still use Twitter, you've no doubt noticed that instead of advertisements for Axe body spray or Ben & Jerry's, both Unilever companies, Twitter is overrun with advertisements for things like brass knuckles, X-rated clothing, and crypto. So much crypto. And the revenue from these advertisers doesn't make a dent in Twitter's $12.5 billion in debt. And Twitter characterizes the advertisers' refusal to return as anti-competitive. Quote, by refraining from purchasing advertising from X, boycotting advertisers are foregoing a valuable opportunity to purchase low-priced advertising inventory on a platform with brand safety that meets or exceeds industry standards. I don't know, that seems like the kind of thing the free market would resolve. But tellingly here, Musk's lawyer is Harmeet Dillon, the new it girl of conservative lawyers. Prior versions have pleaded out. Dillon made her bones during the COVID-19 crisis when she repeatedly sued Governor Gavin Newsom for things like not including gun shops on the list of businesses that could stay open because they provided essential services. And Dillon tried to get herself elected as chair of the Republican National Committee, but you have to marry a Trump son to get that job. But it's a classic tell when no reputable lawyer will file one of these lawsuits and you hire a lawyer that has zero expertise in the First Amendment or antitrust law. Things that would be pretty relevant to a lawsuit that deals with the First Amendment and antitrust law. But is there any merit to the claim that X was the victim of an illegal boycott? Well, the lawsuit sues defendants for 2 counts of violating the Sherman Antitrust Act, 15 U.S.C. Section 1. The Sherman Act prohibits any contract, combination, or conspiracy in restraint of trade or commerce among the several states or with foreign nations. Section 7 of the Act allows a private individual or company to bring a separate suit for 3 times the amount of damages sustained. And the complaint accuses defendants of collectively agreeing to adopt and enforce GARM's standards and using their market power to coerce social media platforms, particularly Twitter and Rumble. The conspiracy to boycott Twitter allegedly started shortly after Musk took over, and the complaint cites several public statements made by GARM around that time as evidence of illegal cooperation. Quote, WFA issued a public letter to Musk on October 31st, 2022, captioned, GARM calls on Twitter to uphold existing commitments on brand safety and deepen future collaboration. The letter warned Musk that, quote, brand safety is non-negotiable for advertisers. The complaint says that the fact that these statements were public proves the existence of a conspiracy. But of course, that makes zero sense. Conspiracies, by their nature, tend to be secret. And the members of GARM just as easily could have worked out their grand conspiracy via an email in secret, but instead they decided to make a public statement. And public statements might lead to action in concert, but mainly because everyone individually chooses to take the same action. But the complaint alleges that the WFA had the power to enforce the boycott. Quote, the recommendations of the GARM member advertiser agencies to their clients to refrain from advertising on Twitter were widely followed. Many of Twitter's largest advertisers discontinued or curtailed their purchases of advertising from Twitter. Now you'll notice that the words widely and many contradict the claims of GARM's so-called power. So there was a diversity of opinion among advertisers. And that falls a bit short of Twitter's big claim that GARM uniformly enforced a boycott. Some advertisers had specific concerns, though it does appear that the head of GARM reveled in Twitter's downfall when they didn't follow their guidance. Quote, while editing a February 2023 draft of an email to TikTok regarding brand safety issues, Rakowitz wrote, I'd like to point out that nowhere in this email is the you may recognize my name from being the idiot who challenged Musk on brand safety issues. Since then, they are 80% below revenue forecasts. Now, because of the boycott, Twitter had to lower the cost of its ads, and that move attracted smaller buyers with smaller budgets, but the big boys stayed away. And the boycott still continues for some advertisers, despite the claim that, quote, X's brand safety practices meet or exceed those specified by the GARM brand safety standards. More than 99% of X's measured ad placement in 2023 and 2024 appeared adjacent to content scored above the GARM brand safety floor, in line with industry standards. Now, Section 1 of the Sherman Act prohibits any contract, combination, or conspiracy that unreasonably restrains trade. And group boycotts can fall under this prohibition if they meet certain criteria. When competitors at the same level of the market structure agree to boycott a particular business or group of businesses, it can be considered a horizontal agreement. And the FTC views horizontal agreements with suspicion because they can eliminate competition and control prices or market access. Horizontal price fixing is per se unlawful. And per se unlawful price fixing includes competitors acting in concert to set the same price at which a product is bought or sold. It also includes any, quote, combination formed for the purpose and with the effect of raising, depressing, fixing, pegging, or stabilizing the price of a commodity. But to prove a horizontal agreement violates Section 1, the plaintiff has to show intent and effect. If the boycott aims to suppress competition, restrict access to the market, or harm competitors, it's likely to be deemed illegal. And this includes boycotts designed to drive a competitor out of business or prevent a new competitor from entering the market. If a group of competitors team up to put a supplier out of business, for example, it would be a direct restraint on trade, and that would be per se illegal. But it's not clear that any of the defendants in this case are actual competitors with Twitter. Ørsted is the largest energy company in Denmark. CVS is an American drugstore. They don't sell competing products and they don't compete with Twitter, but the complaint considers them to be competitors because they both purchased ad space on Twitter. Now, former policy director at the FTC and current antitrust lawyer David Balto, in a Rolling Stone interview, called Elon's lawsuit a, quote, hideous joke. He said, quote, it's not a question of whether or not Twitter lost some money. It's a question of whether or not Twitter was competitively disadvantaged by their actions. There is no evidence in this complaint that they were competitively disadvantaged. And it's also not clear that refusing to advertise on a platform en masse is even anti-competitive. In fact, maybe just the opposite. As Louis D. Lorenzo, an antitrust lawyer at Davis & Gilbert, explained, quote, the Federal Trade Commission explicitly acknowledges the pro-competitive benefits of trade organizations setting standards to make the industry operate more efficiently as a whole, such as setting interoperability standards. This is a group saying we have moral, ethical, and brand safety problems with working with a competitor. We don't think we should work with them. That, to me, is not really an issue. The antitrust issue comes where they're looking to change prices in the market or exclude competitors in some way. And if Musk were right, then no trade industry could exist in the entire world. And one of the key issues in this lawsuit is whether the advertisers were acting in concert or simply making decisions on their own based on the same information. But honestly, the key issue here is the First Amendment, and whether advertisers were acting in concert or simply making decisions on their own based on the same information. Group boycotts are often protected by the First Amendment, particularly where the boycott is a form of expressive conduct. For example, in the case NAACP versus Claiborne Hardware, the court ruled that a boycott by African-American citizens of white merchants to protest racial segregation was protected by the First Amendment. In that case, the local chapter of the NAACP drafted a document with 19 demands for racial justice. White business owners sued for economic damages, but the purpose of the petitioners' campaign was not to destroy legitimate competition. It was to vindicate rights of equality and freedom that lie at the heart of the 14th Amendment itself. In the Twitter case, GARM and brands can point to specific things on Twitter that they are against, especially when Musk himself is tweeting out diatribes about Jewish people or Muslims or immigrants or other groups that he dislikes. However, the Supreme Court reached a different conclusion in Federal Trade Commission versus Superior Court Trial Lawyers Association. In that case, the court appointed lawyers who represented indigent defendants in Washington, D.C., started a boycott, and they refused to accept new cases in an attempt to convince the District of Columbia government to raise their salaries. It worked, but the Supreme Court upheld the FTC's complaint. And the court did not buy their lawyers' argument that the boycott was a means of obtaining social justice for their clients. The court ruled that, quote, the boycott was the means by which respondents sought to obtain favorable legislation and threw out their free speech defense. But the court drew a distinction between Claiborne Hardware, where the defendants sought only the equal respect and equal treatment to which they were constitutionally entitled, and the trial lawyers who wanted economic gain for themselves. And here, Twitter's allegations that the advertisers are actually hurting themselves by not advertising on Twitter is going to come back to bite them. But generally then, if the primary objective of a boycott is based in the First Amendment rather than an attempt to restrain trade or harm competitors, it's likely to be protected. And here it doesn't look like GARM and the advertisers were trying to get favorable advertising rates for themselves. If they were, they would have returned to Twitter as soon as Musk dropped the ad rates. But honestly, who knows what this is going to look like in front of Judge Reed O'Connor? And while 99% of judges would dismiss this lawsuit on the pleadings, who knows what Judge Reed O'Connor is going to do? And that's one of the problems when someone files a clear SLAPP suit in a jurisdiction without an anti-SLAPP law, which Twitter did here. The plaintiff will point to issues of fact that need to be investigated through discovery and avoid an early motion to dismiss. This, of course, drives up the cost exponentially and means that even if you win as a defendant, you still lose because you had to spend millions of dollars for defense through discovery. But we can expect defendants here to argue that the advertising industry has an interest in self-regulation based on their concerns about the content that Twitter hosts. This is especially true because Musk is a volatile personality with a habit of making personal attacks on advertisers and their leaders. So I'm sure the advertisers will say something like, we didn't need to collude to know that people who do business with Musk get burned, and we decided we didn't want to get burned. And apart from being associated with racist or inflammatory language, a lot of these brands just don't want to be caught up in politics at all, which is increasingly difficult given that Musk literally just had a softball interview with Trump and endorsed him for president via Twitter Spaces, if you were able to get in. But guess what? Breaking news. It just so happens that Judge O'Connor happens to be a Tesla stockholder. His 2022 financial disclosure indicated that he had between $15,000 and $50,000 in company stock. And his 2023 disclosure form is not publicly available, and he requested an extension. Now, the appearance of bias alone can be enough to warrant recusal. And after NPR reported on the judge's investment in Tesla stock, Judge O'Connor surprised everybody by recusing himself from the case. His order gave no reason, but instructed the court to assign the case to another judge per the usual procedure. The case was then assigned to another judge in the Northern District, James E. Kincaid, who was appointed by George W. Bush. Meanwhile, Musk's glitch-ridden interview with Donald Trump may have given advertisers yet another reason to stay away from the platform. And in particular, Musk and Trump discussed their love of union busting. Trump said,
I mean, I look at what you do. You walk in and you just say, you want to quit? They go on strike. I won't mention the name of the company, but they go on strike and you say, that's okay, you're all gone. You're all gone, so every one of you is gone.
Now, we don't know if Trump was referring to a specific incident, and he might not have been, but it raised the ire of the United Auto Workers who filed a federal labor charge against Musk. Not surprisingly, federal law prohibits workers from being fired for striking. Now, threatening to fire workers is barred by the National Labor Relations Act. Now, this is a nonsense case that's almost certainly going to get dismissed, especially now that Judge O'Connor is off the case. And that's reflected in news reporting, too. What's interesting is that Elon Musk suing GARM has been covered extensively by over 30 news outlets. 34% of the reporting is coming from the left and 31% coming from the right. But if you compare the headlines, you start to see some interesting framing emerge. On the center left, you have outlets saying that Musk, quote, sued a nonprofit advertising group out of existence. And on the right, you see essentially the exact same thing, but declaring in all caps success. Now, depending on which article you see first, your view of the story can be completely different. If you read left-leaning sources, you might be worried that Musk can wield so much power through our tort system, as with the CNN headline. And if you lean right, you might be happy to think the lefty organization has bit the dust, whether or not the assessment is true. Now, this is all possible thanks to today's sponsor, Ground News, a website and app developed by a former NASA engineer on a mission to give readers an easy, data-driven, objective way to read the news. Ground News gathers related articles from around the world and across the political spectrum so you can see the bias and compare coverage. Every story comes with a quick visual breakdown of the political bias, factuality, and ownership of the source's reporting, all backed by ratings from 3 independent news monitoring organizations. For all the stories on Elon Musk's childlike assertions of power, not only can you see the coverage details and political bias, but you can see the factuality and ownership of these sources' reporting. One of my favorite parts is the bias comparison feature, which highlights specific differences in reporting across the political spectrum. This can be especially helpful when reading stories from sources you've never heard of, where there's no telling who owns it or what the agenda might be. I also love their blind spot feature, which shows you stories that are unreported by either side of the political spectrum. It helps explain why we often talk past each other and some people seem hyper-focused on what seems like nonsense, often because some random blog post went viral among certain people. All of this is why Ground News is my favorite way to get the news. And as a legal eaglet, you can save 40% off the Ground News Vantage subscription by clicking on the link that's on screen or down below. This subscription gives you unlimited access to every feature, including the Bias Insight tool, the blind spot feed, and by subscribing, you'll support an independent news platform working to make the media landscape more transparent. So click on the link below. And after that, click on this link over here for more Legal Eagle, or I'll see you in court.